Yes.
May I please my lords know that I beg to appear for the Union of India and lords the respondent number 8 before my lords note in this matter.
Mr. Jamil, anything is more to be submitted by you? You were continuing on the day.
Yes. Lordships, to make the matter more clear,
Yes.
on the last occasion, that is on 9/4/2024,
Yes.
this honorable court has passed an order in what manner the parties has to address
Yes.
the honorable court. And if we look at the order dated 9/4/2024, particularly the paragraph 5, Lordships will find one order. This is how this honorable court has directed to address the court by the parties, Lordships. And prior to this order, the reference made in paragraph 5 is order dated 14/2/2023. There in that order, to be precise, in the next page, because first, page number 2 is with regard to the party's appearance, but the operative portion, it starts from page 3 of order dated 14/2/2023. I am referring to the order passed by this honorable court on 14/2/2023.
Yes.
And in the page 3 of the order, may I read the operative portions?
Yes.
In the course of deliberation, taking note of the order dated 4/8/2022, two queries of the court are as follows. A, whether in the light of Article 371A, Clause 1, so Clause A, Roman 4 of the Constitution of India, in the absence of any resolution by the Legislative Assembly of Nagaland, the government of Nagaland would have the legislative competence to frame the Nagaland Petroleum and Natural Gas Regulations 2012 and the Nagaland Petroleum and Natural Gas Rules 2012. B, whether in a PIF, it would be appropriate to quash and set aside the said 2012 regulations and 2012 laws on account of lack of legislative competence. Accordingly, all sides, while making their submissions, will also address the point which have arisen in today's deliberation. So, as per this order, the parties are directed to address this honorable court on two queries, which was made earlier. Now, coming to the clause 1.
I mean, Sir Kian Balgopal is trying to address us. Sir, Daniel. And by Kian Bal, Advocate General Nagaland. His video is not coming. You may inform Mr. Balgopal. I think his video is not on, but his hand is speaking.
I'm here, though, yes, I'm here.
You have to put on your video.
In fact, it's not opening. I will just try again.
Okay.
And I will only make a request to your lordships that as far as the link is concerned, if you could get it a little earlier, we just got the link 2-3 minutes back. No, we had asked yesterday. But we will try to set it right. We try to set. I can hear them. I'll follow it now. Yeah.
Yes.
Let it proceed, Lord. Now, coming to clause A, that is the query one. Whether in the light of Article 371A, clause 1, so clause A, Roman 4 of the Constitution, in the absence of any resolution by the Nagaland Legislative Assembly of Nagaland, the government of Nagaland would have the legislative competence to frame the Nagaland Petroleum and Natural Gas Regulations 2012 and the Nagaland Petroleum and Natural Gas Rules 2012. First, let us confine to this query, lordships. And this query, that is clause A, is apparently contrary to the earlier order passed by this honorable court on 8/2/2019. I want to make it, lordships, very clear to streamline the issues. What was the order passed? Otherwise, if we proceed further, then it will be too late to come to this issue. And then it may complicate the matter and unnecessarily will be wasting time. That is why I'm trying to streamline the issues, lordships. The order which has been passed, the query on 14/2/2023, this similar, on the same point, another order was passed by this court on 8/2/2019, where it says about the resolution taken by the Nagaland Legislative Assembly on 26 July 2010. That a resolution is already there. First paragraph will make it clear, lordship. And that resolution is also available in the PIL, that is at page 142.
I'm going to do
Yes.
My lord, at the cost of interruption, my lord, they are not allowing our video, the technical side. We have been trying to contact them kindly. I'm sorry, my lord. My junior lawyers can go and be in touch with them. We are trying to.
Okay, we'll see. We'll see.
I'm good. I'm good.
Okay, I'm told that there's no issue with any network with any issues here. I think it's a network problem at your end, Mr. Balgopal.
Press
Please-
such and such.
Please disconnect and reconnect again. I think that will solve your
Very
problem.
Has lordship got the order dated
Yes.
8/2/2019? In the first paragraph itself, it is mentioned. And again, kindly come to annexure 6 of the PIL, that is page 142. That is the text of the resolution taken by the Nagaland Legislative Assembly on 26 July 2010. The same resolution is also enclosed in the government affidavit, in the additional affidavit of the government, that is the state of Nagaland, respondent number 1, 5, and 6. there they have also enclosed the same resolution.
Yes.
Therefore, Lordships, the query in clause A is already answered. Because the query was in absence of any resolution by the Nagaland Legislative Assembly, whether the government of Nagaland will have the authority to issue the notification. So that is already, there is already a resolution by the Nagaland Legislative Assembly on 26 July 2010. Therefore, I believe that query will be answered by the document as well as the earlier order passed by this honorable court on 8/2/2019.
Okay. But still the issue relating to the legislative competence
Lordship.
for this relation will still be an issue which has to be answered.
But so far as that query is concerned, I believe
Ah.
that will answer the points
Resolution is
that
there.
there
Resolution
is
available.
already a resolution.
Yes.
Now, the only issue left is whether the state legislature will have the competence to frame the regulation as well as the rules. So if lordships are clear on that point, we can switch over to the next issue, that is clause B, whether in a public interest litigation, it will be appropriate to quash and set aside the regulations of 2012 and the rules of 2012. That is the second issue.
Yes.
And there is already an order also on 15/3/2021, whereby it says that the maintainability of the writ petition PIL shall be considered first before going into other aspects. So that is also there. So the fact remains, taking into account of all the orders passed by this honorable court, the relevant issue and question would be for this honorable court and lordships, whether in a public interest litigation, it will be appropriate to quash and set aside the regulation of 2012 and 2011. That is to be decided, and thereafter, if a conclusion is arrived on that, then we can proceed to the merit with regard to the confidence of the state legislature vis-a-vis the application of union laws.
Yes.
On the second point, lordship, first thing first, if we go to the initial stage, the Lotahohu has filed a public interest litigation because the field agreed that large number of beneficiaries are being adversely affected. Therefore, it was felt appropriate to file a public interest litigation so as to challenge the regulation of, in short, lordship, regulation of 2012 and the rules framed around. It was a public interest litigation. Why? Large number of publics are being affected. Public interest is affected. Therefore, the PIL was entertained and interim order was also passed. Now, to consider a PIL, who is aggrieved and who is benefited? How this PIL was conceived and what public interest would be served by deciding this case as a suo motu PIL. If we look at the entire background of the case, the Lota who has initially filed the public interest litigation, they thought it appropriate not to proceed. So they have withdrawn, and this honorable court was gracious enough to allow the Lota to back out from the case and allowed to withdraw. However, on the same day, a suo motu PIL has been registered. I have considered the number of orders which has been passed in the subsequent stages, but the genesis of registering the suo motu PIL dates back to 8/10/2015. The order dated 8/10/2015 passed by this honorable court, and I would like to draw your lordship's attention only to the relevant portions where we are concerned, because if I read all the entire background, the precious time of this honorable court would be wasted. So I would like to just straight to the point, draw your lordship's attention to page 4 of order dated 8/10/2015. This is how the observation was made. Tentative view was taken by this honorable court, and the suo motu PIL was subsequently registered by a subsequent order. From page 4, it's only 2 pages, so lordships, for the convenience of all, I may be allowed to read the relevant portions so that everything will be clear, lordships. This order was passed, lordships, at a time when Lota was aggrieved and before the withdrawal of Lota. The petitioner has not withdrawn at the time of passing this order. The withdrawal by the petitioner is subsequent. So I may be allowed to read the relevant.
Yes. Yes.
Page 4 of order dated 8/10/2015.
Yes.
May I read from the second paragraph, Article 246. The sentence starts from Article 246 of
Yes.
the Constitution. Has your lordship got it?
Yes.
May I read? Article 246 of the Constitution of India deals with subject matters of laws to be made by the Parliament and by the legislature of states. In terms of Article 246, 7th schedule of the Constitution envisages 3 lists enumerating different subjects covered by the 3 lists. List 1 is the union list, list 2 is the state list, and list 3 is the concurrent list. Subjects enumerated under list 1 are within the exclusive dominion and legislative competence of the Union Parliament. Entry 53 of list 1 deals with regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, other liquids and substances declared by the Parliament by law to be dangerously inflammable. Thus, prima facie, we are of the view that exploration of oil and natural gas is a subject which is covered by entry 53 of the Union list, which means that it is the Parliament which has the legislative competence to enact laws on this subject. Next paragraph. Article 371A of the Constitution deals with special provisions with respect to the state of Nagaland. Clause 1A of Article 371A provides that no act of the Parliament in respect of religious or social practices of the Nagas, Naga customary law and procedure, administration of civil and criminal justice involving decisions according to Naga customary law, ownership and transfer of land and its resources. This we are concerned with. Shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. A careful reading of the aforesaid provisions or show that no central legislation in respect of the aforesaid subject shall apply to the state of Nagaland unless the same is adopted and made applicable to the state of Nagaland by the Legislative Assembly of Nagaland. This constitutional provision, which has been heavily relied upon by Mr. Takamasa, learned senior counsel for the petitioners. In our opinion, this is important, where how the case was registered. In our opinion, is meant to ensure protection of various aspects of Naga way of life and social practices, as well as ownership and transfer of land and resources. It does not, in our tentative view, it starts from here, confer further competence of the Legislative Assembly of Nagaland to legislate on a subject which is within the exclusive domain of Indian Parliament. This is an aspect which may require further deliberation of this court. Since the very source of power for issuance of the imbuement permit in favor of respondent number 7 is highly questionable, both legally and constitutionally, we are of the view that it would be in the interest of justice if the effect and operation of the said permit is kept in abeyance till the case is finally decided. This is more so because we have noticed that the imbuement regulations and rules are not only legally questionable, but those do not provide for any safeguards and provisions for compensation to the landowners in the process of oil exploration until and unless oil is discovered. Moreover, respondent number 7 has failed to show any active, sincere activity since issuance of the imbuement permit. Respondent number 7 has also not placed any materials before the court to show any investment allegedly made by it. Accordingly, the imbuement permit dated 28/2/2014 issued in favor of respondent number 7 is hereby stayed until further orders. This order was again, there is another subsequent order on 8/2/2019 where the same order was also stayed. Accordingly, the list this BIL for hearing before the next available division bench. Meanwhile, the respondents may file their respective affidavits. Now, looking at the order passed by this honorable court on the last occasion, the reference was made to Article 246, and the text of Article 371A has been quoted almost in the same line, but no further discussion and deliberation how this 371A has been inserted in the Constitution as one of the articles. So a prima facie opinion was formed that the state legislature will not have the power. It is the central government who has the power to make a law on this. So that issue, keeping in view of this, on the last occasion, this honorable court has also formulated the 2 grounds. Out of the 2 grounds, before I go further to other aspects, I would like to cite the one decision of the Apex Court passed in 2003. I believe that has not been overruled till date, consisting of 3 judges headed by Honorable Chief Justice of India, 2003, 7 ECC, 546. Because the query is with regard to the whether it will be appropriate for this court to quash and set aside a regulation and the rules framed by the Legislative Assembly of Nagaland.
You give me a copy, please.
Just a minute. Page. Copy खा गए सर whether it will be appropriate for this honorable court to quash and set aside the regulations and the rules in a public interest litigation. No doubt, this honorable court has a long hand where the public interests are adversely affected. Yes, definitely, this honorable court has a long hand to interfere. But then there are certain limitations where the restrictions have been imposed. That is the reason why I was raising some points. Who is the aggrieved party? In what manner they are adversely affected? By not interpreting Article 371A, who is adversely affected and whose interest is suffered? Now, relevant portion, lordships, kindly come to page, it's paragraph, page 571, paragraph 50 at subpara Roman 11.
Sorry, what?
Paragraph 50,
5C.
yes,
Thanks.
Roman 11. It says, ordinarily, the High Court should not entertain a writ petition by way of a public interest litigation, questioning the constitutionality or validity of a statute or a statutory rules. Here, three things are covered: constitutionality, validity of the constitutionality, statute or statutory rules. We are concerned with the regulation of 2012 and the rules made thereunder in 2012. May I proceed further? That is with regard to the maintainability. On the last occasion, to some extent, I have made some submissions with regard to the background, how this 371A, but then to be precise, I'm not citing the background from 1874, how the law was evolved with regard to the special status for the state of Nagaland, but just coming up to 16-point agreement, that is 1960, where the 16-point agreement was signed between the Government of India and the Naga People's Convention. And in clause 7 of the agreement, the present Article 371 is mentioned, and at the time of deliberations in the Parliament, the entry 53 in the Union list was already there. 7 schedule was there. Different entries were there. And they are fully aware of all these entries. And discussion was held. But since a political agreement was signed between the Naga People's Convention and the Government of India, they have agreed. So it has to be incorporated in the Constitution. So the certain amendment was proposed, bill was prepared, and in the bill, 2 things were proposed. One, the State of Nagaland Act, which Lordships has also referred to, by the State of Nagaland Act 1962. First was the proposal to create a state under the Union of India. And the second is for insertion of this point number 7 of the 16-point agreement in the Constitution as one of the articles in the Constitution. Therefore, this was there 371A is to be inserted in the Constitution as a special provision. Why it is treated as a special provision? Because it cannot be mixed up, it cannot be treated like any other general principles and law. Therefore, it was a special article for the state of Nagaland in view of signing of 16-point agreement between the Government of India and the Naga People's Convention. Am I clear, Lordship, on that point? Therefore, a special provision is to be treated as a special at the time of registration of the suo motu fide. This aspect of the matter was also not discussed, that it is a special provision, special to the state of Nagaland. Land holding system is totally different with the rest of the country. One. Secondly, the creation of the state itself is arising out of a political agreement. All other states, as I was submitting on the earlier occasion, has been created on the basis of the recommendation of the state recommendation committee and the State Reorganization Act. Whereas the state of Nagaland was created out of a political agreement. That is why a special provision was inserted in the Constitution with a non-obstante clause that notwithstanding anything in this Constitution, no act of the Parliament shall be applicable in the state of Nagaland in respect of, and then 4 clauses are there, unless the state legislature of Nagaland by a resolution so decides. So, for application of any union law under 4 clauses, it is an admitted fact that the Constitution says that unless a resolution is taken by the Nagaland Legislative Assembly, it will not be applied. Now, the question comes, if the union law cannot be applied and these 4 clauses, who should make the law? A law which was made in 1937 by the British government. It is still applied on the same subject, which was framed under the Civil District Act 1974, under Section 6 of the Act. That is still prevalent for the last more than 80 years. If we are to interpret like any other general provisions, it is very clear, and I'm also in agreement with what the tentative view was taken by this Honorable Court on the earlier occasion is, without 371A, any law made by the state cannot be applied, which is covering on the subject union list. The scheme of Constitution has clearly identified and defined the lawmaking power between the union and the state under the 3 list, clearly given. And when a dispute and question arises, from time to time, problem arises in view of some political reasons, in view of some vested interests, conflict arises among the 3 lists. When such a situation comes, abundant care should be taken that the scope of constitutional scheme has to be understood first, and thereafter decided. Now, in
You were you were referring to this 1937 Act.
Lordship,
It-
Rules.
it is- Rules, huh?
Rules.
It is in what context? I missed it out.
it provides the procedures, how the civil and criminal cases has to be handled and dealt with.
What is that rule?
1937 rules.
What is the need?
Rules for administration of justice and police in Nagaland,
Oh, acha.
1937. And all the court proceedings in the trial courts mostly filed under that rules. Even in the High Court, there are some provisions. Lordship has dealt with so many cases of a similar nature. And even the other three clauses, there is no issue till date. On 371A, there are four clauses. The religious and social practices of the Nagas, Naga customary laws and procedures, administration of civil and criminal justice, decisions involving customary laws, only the transfer of land and its resources. This issue has come in view of filing up a public interest litigation by the Luta Home. But then subsequently they have withdrawn. Now, the registration of the very PIO Somoto by the Honorable Court on 8/2/2019. The reference which I have shown to your lordships, which was passed on 8/10/2015. This was taken as the basis that since an observation was made, tentative view was taken on that day. So it has proceeded like that. So as per the last order, the parties were directed to address on this point. That is why before going further, I'm just referring to this, whether it will be appropriate for this Honorable Court to interfere and quash the regulation of 2012 and rules of 2012. So I believe so far as that aspect is concerned, that will govern, taken care. And just a gist. It is on the last occasion also, we were deliberating on the point that, yes, under clause T, Roman 4, the transfer of land and its resources. Any law made by the Union Parliament in the four clauses will not be applicable unless a resolution is taken by the Nagaland Legislative Assembly. That issue is admitted, yes. Then, who should make the law? That was the issue. Because there is no specific mention in the article, in the clauses, that state legislature will frame the rules and pass an act on this. But apparently, of course, this is my only understanding. It is implied that when union law cannot be applied under four clauses, then it is implied that the state legislature will have the power to make law on this. Otherwise, if it is answered, no, state government do not have the power to make law on these four clauses, then the next issue comes. Then who should make the law? Do you mean to see that nobody should make a law on this point? So it should remain like that for all the time to come. That cannot be a reasonable law, I believe. So there has to be some authority to make the law. And by reading Article 371A, it is implied that the state legislature will have the law. Otherwise, there is no need to insert this article in the Constitution. Because how to recollect how three lists should be applied, it is clearly mentioned in the 7th schedule. Constitutional provisions are very clear. So, after creating the state, there was no need for inserting another article for the state of Nagaland. But since it is a political arrangement, political agreement, state has been created out of a political agreement. This 371A was inserted with the non-abstandi clause that even if other laws are there, it will not be applicable because the members of the parliament were very much aware about the existence of entry 53 and 54 in the union list. And unless this is put in this manner, there will be definitely conflict, misunderstanding. That is why after deliberation, it was inserted. When the issue arises, when there is ambiguity, how to decide? Then Number one, what should be the aid so as to interpret these provisions properly? Lordships are well aware. The statement of objects and reasons of the bill. What was the objectives? What is the reason for inserting this, for doing a particular thing? So statement of objects and reasons, common affidavit has enclosed, and they have clearly explained about this. Number one. Number two, if it is not clear again, we have to go back to the parliamentary debates. What was the debates in the parliament during that time? At the time of introduction of the bill in the two houses, what was the discussion? So I believe it is Renuka Chowdhury, Srimati Renuka Chowdhury, not the present one. I think in 1962, it was an MP from Assam. I'm not very sure, but she is from Assam. And if we look at her speeches, it is wonderful. I should say marvelous. Beautifully, she has explained about the background, what the Jawaharlal Nehru said. Everything was discussed in detail. So taking into account of all these aspects, Lordships, I feel that, yes, the insertion of this article is with the view, with the objective to grant some benefits, grant some protections to the people of Nagaland. I'm only the amicus curiae, but then at the same time, I feel that it is my duty to discuss all this point when we discuss about the insertion of the provisions in the Constitution, Lordship. The background should be understood. Once we understand that, I think there should be no difficulty in interpreting the provisions. The statement of objects and reasons of the bill is very clear. The 13th Amendment of the Constitution is very clear. And I have read a few legal opinions rendered by the legal luminaries of the country in this regard. Sri Vai, V.C. Sarkar, S.K. Sen, A.V.S. Nariman, all of them were having this common view, same view. Subsequently, in the recent times also, on several occasions, the Attorney General of India has been consulted with regard to this lawmaking power. Almost all of them were of the same opinion, except one opinion in 2010, sometime in 2010, who has given a different view. And I believe he may not have considered thoroughly about the background, how 371A was inserted, and what the opinion he has rendered is absolutely correct without 371A. I also consent to that same opinion. Yes, whatever tentative view was arrived by this Honorable Court on 8/10/2015 is absolutely correct, no argument, without 371A. Very clear.
Mr. Zamir,
Lordship,
Article 371,
Lordship.
it says that
Temporary provision.
notwithstanding anything in this constitution, no act of parliament
Lordship.
will apply. Meaning thereby, there could be an act of parliament. It may be in existence
Lordship.
on a subject matter included in list 1. But it will not apply directly unless a resolution of the Nagaland Legislative Assembly is passed.
Lordship.
Whether by implication, if no resolution by the Nagaland Legislative Assembly is passed,
Yes.
will empower the Nagaland Legislative Assembly to
To make law.
legislate on a field
Yes.
which is otherwise in list 1.
Yes.
Now, if we go by Article 254, because it acknowledges that
Repugnancy of
no, yes, but repugnancy is only in respect of list 2,
Yes.
not list 1.
Correct.
Now,
Fully agree.
yes, then by implication, the Nagaland Legislative Assembly will not have the legislative competency to enact on any matter in list 1. Repugnancy is only in respect of
These two.
list 2,
Correct.
if it obtains assent of the president. So, this otherwise goes to show that Nagaland Legislative Assembly will not have the competence. So, what is your
Yes.
answer to it?
I believe this will be my third round of submission on this point.
Okay, okay.
How, from what is,
Because
if I remember correctly,
371
Lordship,
acknowledges existence of acts of parliament.
Lordship,
You cannot discard it altogether.
correct. If I remember correctly, Lordship has put a query on the last occasion also, not last time, but before that. Where is the source of power? What is the source of power for the Nagaland Legislative Assembly to legislate on this in absence of any specific portion? That was the query. And I believe a similar query today also, more or less substance is same. Now, to answer that, we have to go back to start from 1874, the background, entire background, how state was evolved and how the things were developed. Insertion of 371A is to provide, to insert certain protections to the people of Nagaland, which they have been demanding for the last so many years. And in black and white, the first representation was to,
Just stopping for a minute. Suppose there is an act of parliament to exploit the resources and the land,
Lordship,
petroleum and mineral resources. One way of interpretation could be if Nagaland Legislative Assembly does not pass any resolution, central government cannot explore. So there will be preservation of land and its resources.
yes,
Preservation of land and its resources for all times to come. There could be another interpretation. Is it not?
yes. That is the reason why I was saying, can it be left in a vacuum for all the time to come? That is the reason why I'm putting a question. What is law for? Why a law is made? For what purpose? For what objective? That is required to be examined. Apart from your Invasion legislature object. Yeah. Can that be a objective of the law? Let me just. I'm putting a query, Lordship. It may not be, not as a query. It may not be the intention of any.
Who will put the query, you will answer.
It may not be the intention of any legislature, whether it is the parliament or the state legislature, to leave a vacuum where nobody should make a law. Therefore, any law made by the union parliament or the state legislature is made with an objective. And if, coming to 371A, if union law cannot be applied in the 4 clauses, 4 subjects, then can it be lived like that? Nobody should make the law. Somebody has to make the law, and it may not be the objective of the union parliament that so far as the mineral resources lying in the state of Nagaland is concerned, for years to come, nobody should make a law, nobody should touch. Since the law made by the union parliament, although they have the power to make, let us assume that they have the power to make the law. But without the approval, resolution by the Nagaland Legislative Assembly, that law cannot be applied. That means, is it your intention to leave this area without making any law on this subject? But in contrast, other 3 clauses, Nagaland Legislative Assembly has made so many laws deriving power from Article 371A, and nobody has any objection on that. Now, the problem lies only with clause 4, that is Roman 4, transfer of land and its resources. That if your interpretation that parliament intention is that on these 4 clauses, state legislature should not make any law because you do not have the power to make law, then union parliament should have raised issues. Union central government should have raised issues. No, you do not have the power to make law on these subjects. But for the last 60 years, more than 60 years, after insertion of this, no complaint, laws are framed basing on 371A, no problem. Now, my direct answer to the query which Lordship has put into me, I'm replying now on that point. Article 371A is the source of power, and also it is the field of legislation. 371A. In other words, this is the source of power for making law under 4 clauses for the Nagaland Legislative Assembly, enumerated in the 4 clauses. It is not from list 2 or list 3, but the power, the source, comes from Article 371A itself, taking into consideration of all the background, a statement of objects and reasons, and the parliamentary debates, and the background, how the state was emerged as one of the states under Indian Union.
You want to say that so far as clauses Roman 1, 2,
Two,
3,
three.
and 4 appearing in Article 370A
Yes.
is
371.
371A is akin to the list Schedule 7
Yes.
for Nagaland Legislative Assembly
Yes.
to enact law on these subjects.
Yes. Yes.
Like a list.
I give a very horrible example. Including giving horrible examples.
So this submission has come. This issue, I think there is no authority on it. No previous precedent. This is the submission
For the first
which
time.
is first time.
Yes. There was no occasion for the last
Yes.
60 years, more than
Yes,
60 years.
Yes.
This issue has not been discussed.
Now, see, let us take an example. The penal laws are made by the Union of India, and the penal laws has to apply under the Adaptation Act
Yes.
of the state of Nagaland.
Yes.
So let us say that the union law, so far as capital punishment or the life imprisonment punishment, is not accepted by the parliament. Legislative Assembly of Nagaland. That part of the penal provision is not accepted. Now, can it mean that the state of Nagaland would again make its laws and then impose a penal punishment just because the adaptation law was not accepted?
You see,
I'm just
there, all the clauses will govern that also under 371A. C, decision, religious and social practices of the Nagas, Naga customary laws and procedures, administration of civil and criminal justice involving decisions in accordance with the Naga customary laws. So custom has been protected there. It is not saying that this no law of the parliament shall be made applicable. There are so many union laws which are made applicable in the state of Nagaland. So many laws have been adopted. Even the latest 3 provisions, IPC and CRPC Evidence Act, which has been repealed, the new law, state government has already adopted. It is being applied. But the 4 clauses under 371A, since this had a demand of the Naga People's Convention and agreement was signed, and it was inserted in the Constitution as a special provision. Therefore, it has to be treated in a special way. And that is why it starts with a non-obstante clause. In the entire Constitution, as many as in 22 articles in the Constitution.
Sorry to interrupt. If you have the Constitution of India with you,
Yes, I have.
come to Schedule 6, just for a moment.
Six.
For a moment, if you don't forget it. About 15 to this situation.
Yes, Lordship.
Say, for example,
Which entry, Lordship?
Schedule 6.
Schedule 6.
6
yes.
schedule to the Constitution.
Yes.
This is for some areas of Meghalaya, Mizoram, Assam,
Yes.
right? Not Nagaland.
Yes.
They are also in paragraph 12
Yes.
or 12A, right?
Yes.
This, if you find, have you found? 12, application of acts of parliament
Yes.
and of the legislature of the state of Assam to autonomous districts and autonomous regions of the state of Assam.
Yes.
For example, I think I'll refer to Meghalaya also. Notwithstanding anything in this constitution,
Yes.
no act of the legislature and some parliament also was there, unless the governor assent permits it.
Yes.
Now, come back to rule paragraph 3. Of 6th schedule.
Yes,
The regional, there specifically source of power is there.
yes,
The regional council for an autonomous region in respect of all areas within such region and the district council for an autonomous so and so, shall have power to make laws with respect to the allotment, occupation, or use, and the setting apart of land. Right?
yes.
The words are allotment, occupation, or use, or the setting apart of land.
Yes,
So, exercising this power, the Meghalaya state has enacted a law, also which includes subtly transfer and ownership of land. Now, Constitution bench of the Supreme Court has said your power is restricted to allotment or occupation or use. No transfer or power or ownership has been given. No source of power is given to you to enact laws transgressing the areas which is specifically in paragraph 3. Right?
yes,
There are instances are there.
Just to add to what falls from my land, if notes will have paragraph 3 and A to J. Notes A to J, all are subject matters which are covered under list 2. None of them is covered under list 1. So whatever power has been given in 3 confers notes whatever is already available to a state. But now it is being devolved to notes the local administration. That's about it. Notes not that it's transgressing list 1. Or notes there's a dilution with respect to the powers which the parliament enjoys with respect to list 1. So that is not notes what paragraph 3 does. No, just to add to what falls from my notes.
From 1960s.
Yes.
yes,
Yes.
1960s. That is why Kitimon or something like that.
yes. Agree. So far as the illustration which Lordship has put about in the entire Constitution, there are as many as 22 articles where the article starts with a non-obstante clause. So also in respect of Meghalaya, it is there. In respect of Mizoram, it is there. In Mizoram, similar provision with that of Nagaland. The only word, one word has not been mentioned, that is the resources. Transfer of land, but it ends there. So I believe the Union Government Parliament has become wiser by committing a mistake in respect of Nagaland.
That was the first one.
Therefore, it implies, even that is an indication and direction towards the benefit that has been granted to the state of Nagaland. And the background, that is why time and again, I'm citing the example of background. Under what background, under what circumstances 371A came to be inserted in the Constitution is different from any other provisions where the article itself starts with a non-obstante clause. It is, we are not denying, we are rather accepting the fact that yes, it is there, even in case of Jammu and Kashmir, but it is totally different. State of Nagaland, the background, if we look at the background, it cannot be mixed up with others. It is totally different. So, Lordships, to summarize, in short, I'm going back to my earlier submissions with regard to the maintainability of the present Somoto FIL. That what I have said. It may be appropriate to arrive to a conclusion. Once we reach to that conclusion, matter ends there also. But if the Lordships are not satisfied, if the Lordships feels that no, there is a wider implication, so let us examine this and merits. That is also another part. But first thing first, once we arrive to a conclusion on the first query, then I believe the matter will end there without much wasting time, Lordship. If any other query, then let me try to clarify, but for the time being,
Solicitor General or as a special counsel? I'm just a counsel. Special counsel. Vivek. Oh. Nice to meet you. You are from sales? Yeah. Sales here. 91 batch. 91 batch. I'm 89 batch. And Apok, I think you belong to same batch. We just met. Yeah. Any idea about Ashish Agrawal? Yeah. He's in Delhi. He is my classmate. Yeah, he was the president in your year. 88, 89. Yes, correct. Yes. Yes. Naimot Pracha. Pracha. Yeah, he was there. And then Viraj Kishore. Two batches senior. He was senior to us. Put up there. Naimot Pracha and Viraj Kishore. Lordship, for the time being, let me hold on there, and unless there is some query from the Honorable Court and the counsel for the respondent number 8 and the learned advocate general will also address the Honorable Court. So for the time being, let me hold on for some time, and then if there is any query, then I'll come back, Lordship. And with regard to the assurance given by the learned advocate general on the last occasion regarding my all this, and it's proceeding in a positive direction. Hopefully, it will be materialized one day or the other. Obliged, Lordship.
We come back to the making of the state of Nagaland political agreement.
Lordship.
I have got it sanctioned, my lord. I told him there will be a lot of administrative problems. So I've taken it upon myself. I've issued him the letter and told him it is my responsibility. And he's satisfied with what we are doing, more than satisfied. Of course, our brother lawyers are also putting in their efforts. They're also working.
Yes.
We should honor it.
We in fact, while passing the order, we forgot about the standing counsel for the High Court.
Whatever directions are given, we'll come. We have no problem. It's after all, we should come forward ourselves in these matters. We'll take care of everything.
Yes. Now who will address us?
Lords, would my learned friend like
Yes.
to address my lords? So,
Well, Advocate General will have precedence.
yes, would have.
You also, I think,
No, Lords,
you are appearing as additional Solicitor
no,
General.
Lords, I'm not an additional Solicitor General. Lords, I had the privilege of serving as the Advocate General for the state of Sikkim.
Okay.
Lords, I have some understanding of Lords, this family of Lords, articles over there.
Okay.
But Lords, the
But,
serving
it's
Advocate
the
General would
reason-
obviously have
yes.
precedence. Lords.
Yes, Mr. Balgobal.
My lord, the state of, the Learned Council for the central government he was to complete his submissions.
Hmm.
And in the last order, it has been specifically mentioned that after his submissions are over, I will complete the final portion so that we don't have to repeat. And that is accepted by them.
Okay, then you may begin.
So just to point out, with my Lord's permission, and I'm grateful, Lords, for my learned friend to allow me the floor. Lords, if Lords will, Lords, as Lords has been so succinctly articulated, Lords, by my learned friend, the issues that are to be considered. Lords, they have been Lords, mentioned in that order of 14th of February 2023. Lords, that clause A and clause B. Lords, if Lords will have that order of 14th of February for a moment.
Yes.
Yes, Manoj, I read notes from page 3 in the course of deliberation. Manoj, are with me? Yes, Manoj, it says, taking note of the order of 4th of August 2022, two queries of the court are as follows. Whether in the light of Article 371A1A4 of the Constitution of India, in the absence of any resolution by the Legislative Assembly of Nagaland, the government of Nagaland would have the legislative competence to frame the Nagaland petroleum and natural gas regulations and rules. Manoj, I'll just pause over here. This question is really in two parts, and two sides of the same coin, but two parts. Absent the resolution of the Legislative Assembly, what happens to the Parliamentary Act? That's one part of the question. The second part is notes that in the absence of the resolution of the Legislative Assembly, notes, does it imply that there is some competence which flows into the Assembly automatically? That's fell from my notes list 4 of Schedule 7, which applies to Nagaland relating to these 4 issues. That's the second aspect, which is the other side of the coin. Now, whether the requirement of a resolution is a disabling protective provision of the Constitution of India, where the customary procedures of the people of Nagaland, as my learned friend said, which was a political settlement, which translated into the article. Now, whether that protective disabling article can be interpreted as a positive, affirmative, enabling article and a source of competence is something which my lords will have to consider. So these are two separate aspects related in some manner, lords, but will have to be considered separately. My own submission is that the answer is not so simple, because when we look at 371A, according to me, there is no conflict. And I will endeavor to establish before my lords that there is no conflict over here.
As per the stand of the state government in their affidavit, Article 371A is not a restrictive but an enabling provision.
Yes, and that will be an interesting proposition, which I'm sure my learned friend will seek to persuade my lords with. But lords, there are no words in the article itself which lords grant that competence, and lords will see it in contradistinction to 245, which is the source of power. And lords are aware, lords, tons of judgments which have categorically said that even 246 is not a source of power. It only delineates the fields or the subject matter relating to which competence may be exercised. But competence flows only from 245. Lords, merely describing a field will not grant competence. Competence is a separate. The source is to be provided separately, as has been done in 245 and as in Schedule 6, Clause 3.
You have filed your affidavit, I believe.
Yes, two affidavits, which are there. No, I'm so sorry, we have not filed written submissions.
No,
So, in
not-
fact, I was going to seek my Lord's leave to file written submissions, which will clearly articulate, the arguments that we wish to put forth before this court.
affidavit or respondent number 8
Yes,
is 342.
So, there'll be two affidavits, One. No, I'm only one which is filed on which day?
What is the affidavit in reply by the petitioner? No.
So this is on 30th of
We are getting only one.
one. There's one. I'm so sorry, there's one.
70, 68.
Page number 3,
And-
second line. Oil Fields Development and Regulation Act 1948.
Para 5,
Para 5, come to page 3,
Yes,
second line.
Yes,
Oil Fields Development and Regulation Act 1948.
Yes,
Very bad. Hey, Beatrice. Very. Hey, oil fields development and regulation act back from 1948. Oil fields development and regulation act 1948. Is it published in this form, book form?
The oil field laws, it'll be with the petroleum laws, we'll also have the PNG RP Act also, and the petroleum rules. also.
Petroleum কিবা ডাঙৰ কিতাপ আছে নেকি? দেখা নাই। Extends to whole of India.
I'm sorry, I did not get your name.
Vivek Kohli.
Vivek Kohli. Okay.
So this act extends to whole of India.
Whole of India. Whole of India. It's a small act, only 12 sections. It extends to the whole of India in terms of section 1, subsection 2.
Mr. Kohli,
Milords.
you see this, when we read this act, section 4
Of Milords.
of this oil fields
Yes,
regulation.
Milords.
So it's not a case that you wanted to exercise some right and that was denied by the state government. So in fact, there is no dispute. The
I'm
central
so-
government is also not creating a dispute. It's not disputing the power, legislative power of the state government to enact this law.
Milords, the Oil Fields Act.
No.
No,
The Nagaland Act.
the Nagaland Act. In our submission, they are those acts are not, they can't be passed.
No, but dispute was never raised. The union government never raised a dispute with the state government about the.
No, in fact, my instructions are that even today, there are discussions going on, and there's a high power committee which has been set up only 2 days back again, for the nth time, where this resolution needs to be. May I just point out for one moment, why while I bow down to what falls from my law, that there's no dispute. For the reason, what we exercise in terms of the Oil Fields Act is competence, which is granted to the Parliament in terms of entry 53 of the list 1. Now, 53 of list 1, if will have immediately, speaks of development and regulation. It doesn't talk about ownership or transfer. May just have that for a moment. May please have that for a moment. Please see entry 53. May have that for a moment. And in all these regulations which deal with development of mining rights, ownership and transfer are never a question. It's only about the regulation on how it will be developed so that end to end, there is proper safeguards and equitable distribution of whatever the resources in the community, or smaller or larger. May have for a moment entry 53.
Yes.
It says regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, other liquids and substances declared by Parliament by law to be dangerously inflammable. So, the only power or the competence which the Parliament exercises and has exercised is relating to regulation and development. It doesn't transcend into ownership and transfer. Now, in contradistinction to this entry, if were to see 371A for a moment, please see what does 371A say. Yeah. 371A, on the other hand, clearly says special provisions with respect to the state of Nagaland, notwithstanding anything in this constitution. May I just point out over here for a moment, while much has been said about this word notwithstanding, and as if notwithstanding is going to give unbridled powers. Lords, notwithstanding, the Supreme Court itself has said, Lords, is limited to the amending power of the to the union, Lords. Lords, the word notwithstanding doesn't confer powers beyond the Constitution, or Lords, impinge upon the basic structure. So, Lords, what is the concept of notwithstanding also, my Lords, will have to consider. Now, Lords, please see what does it say after that. A, no act of parliament in respect of. Now, Lords, these are only the subject matters. Ownership and transfer of land and its resources. So, Lords, there's ownership and transfer on the one side and land and resources on the other side. So, Lords, what would ownership and transfer mean in the context? No, the text has to be in, Lords, as my learned friend rightly said, the historical context. What does the term ownership and transfer mean? And what do land and resources mean? These are two separate things, Lords, which Lords will have to consider. Lords, I'm not claiming, I don't stand here claiming that no, I have the ability to transfer or own. I only seek to exercise the power to regulate and develop for the benefit of the community, whether, my Lords, at a village level or at the larger national level. But I seek to my competence only with respect to regulation and development. And then, my Lords, the second part of it shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. Now, my Lords, an impression is sought to be created that absent the Legislative Assembly's consent, there is a vacuum created. And, my Lords, this competence on these four fields, to legislate on these four fields, falls in a vacuum. And therefore, naturally, absent the consent of the Legislative Assembly, the Legislative Assembly will acquire that competence. In my humble submission, that is not correct. I will demonstrate. Will please see the four entries for a moment. Religious and social practices of the Nagas. Religious, forget for a moment Nagaland. Religious and social practices doesn't find a mention anywhere in the three lists. This is a purely defensive clause for the culture and heritage of Nagaland to be protected. Simplicity. Or Maloj could by extension say that the residual powers in terms of list 1, which vests with the center, it's a protective clause against that. That if in exercise of the residual competence, the center does make a law, then the Naga customs will prevail. Religious and social practices. Now, please see 2. Naga customary law and procedure. Now, customary law and procedure, which is again an aspect of culture and heritage. That also is a defensive. And if provision, and if there is a affirmative act of center pinging upon a social practice, then the Naga people are protected. And may I straight away give an example over here. Are aware, some time back, possibly last year or the year before, there was this matter in the Supreme Court relating to the Sabrimala temple. Kerala doesn't have this protective clause. Now, therefore, the Supreme Court, by a majority judgment, interpreted that no, 14 would prevail over the customary practice. Now, I ask myself the question, if Sabrimala were to be placed or were to be situated in Nagaland, and there was a practice that in that temple only men could visit, would that be protected under 2? In my humble submission, of course, it would be. The Legislative Assembly could step in and could say that we are not giving our consent to this. And therefore, that temple would continue with its practice. I don't wish to comment on the merits of the practice. That is irrespective. The contract with the union is that that practice will be respected. That's about it. So that is what 2 customary practice, customary law and procedure protects. Please see 3. Administration of civil and criminal justice involving decisions according to Naga customary law. Now, civil and criminal justice both form part of list 3. So, where the center makes a law and the Naga Legislative Assembly doesn't agree with that law, then competence flows through list 3. to the Legislative Assembly to make a law which will govern Nagaland. So, my lords, it's not a vacuum in any manner. There is a competence, list 3. I'll take my lords through the entries, which my lords clearly provide. So, please see 4 for a moment. Ownership and transfer of land and its resources. I'll again take my lords through the entries, which my lords clearly in list 3 provide, and list 2. That, my lords, where the center makes a law and, my lords, the competence flows to the Legislative Assembly in terms of list 2 and list 3. So there is no vacuum. The only difficulty, my lords, is that list 1, which prevails, my lords, in terms of 246, my lords, list 1 picks out development and regulation of oil fields. No,
They can come back.
I'm so sorry.
Has this word resources been interpreted in any judicial pronouncements?
Yes, no, Supreme Court has said about resources. I'll not place all of that also. The Supreme Court has also said about ownership and transfer. So, land also, they've described. In fact, there is a direct judgment of the Supreme Court, which says under the Minerals and Mines and Mineral Development Act, where the Honorable Court has said that this has nothing to do with ownership. This is only relating to development and regulation. That's all. And there should be uniform practice. That is a desirable thing. So therefore, there's nothing relating to ownership. And in fact, the court goes on to say that the resources below land, above land belong to the owner. And they've also drawn a distinction between 294 and 297, which deals with the economic zone, which is under the ocean, and onshore, which is available, and the distinction between I'll take my notes through all of that, that will be important. But prior to that, as I was saying, that there is no conflict as such, harmoniously read in my very humble submission, which will be my case, harmoniously read, the competence I wish to exercise does not vest with the state government. It does not impinge on Article 371A, subclause 4. It doesn't impinge on that. And therefore, there is no need for me to obtain the consent of the Legislative Assembly. So, as far as the first part of the coin, as I said, the first side, as far as the application of my Parliament's Act is concerned, the Central Act, I don't need a Legislative Assembly permission over there because it doesn't fall in 371A4. And therefore, that act applies. Now, on the other hand,
No. It's not, because you'll have to interpret and tell us.
Yes.
You see, what happens is that in the state of Nagaland, the state is not the owner of the land. It's the people.
Yes.
So therefore, if you have said that the Supreme Court has also interpreted that the land would mean the things above the land and below the land, then that automatically becomes the ownership vests with
Absolutely.
the person.
Please see over here. What we are.
Therefore, you see, therefore, in the guise of regulating,
Yes.
you can't step in.
No, I'm only saying, may please see for a moment. Ultimately, we must, in the context of what are we really attempting to do here? We are sitting on a parcel of land and acreage, as is known as in the oil and gas sector. An acreage which is suspected is a potential candidate will have mineral resources. And I mean, mineral resources in my arguments today, would mean oil and anything relating to petroleum products. Now, it's a good candidate. Now, the process of finally achieving petroleum products is not really that simple. There is the process where after identification of the land, there is a great amount of seismic and under the earth investigation which is done to identify the potential of the land and whether it is commercially developable. And then after this entire investigation, which is phase 1 of the stage, the second phase is where the exploration has to be done. Now, the exploration, as are well aware, I'm so sorry if I'm explaining it in too much detail, But just notes to maintain the continuity of the thought notes. In the exploration stage, notes, there has to be drilling. Now, notes, drilling is not really notes, what we do in Delhi, notes, which is the borehole, and we go down to 35 meters and extract water. Notes, it's not really that. This is scientific drilling, notes, which has to make sure that whatever is the product, they are able to seal the well, preserve notes, the hydrocarbon, and then notes, put up in the development stage. This is after the exploration. Notes. In the development stage, they are able to drill development wells, and they are able to then manage the extraction of the resource in a manner where the underneath of the tectonic plates or the underneath of the earth doesn't kind of get disturbed in any manner. So the rate at which the exploitation takes place over the period that it takes place, this is all determined by what is the significance of the land underneath. And then comes to the refining stage. Now, for a village community to do all these acts is an impossibility. It can't be done. So, there has to be, even for the national government, are aware, ONGC was specifically set up for this. But after that, even the government realized that at this pace, we will never be able to extract the potential of India or exploit the potential of India, which is why in the Vajpayee government, they came out with that new exploration license policy, the NELP. And private participation was invited. Because that's the only way it can be done. And this involves not dollars, it involves billions of dollars. And there is a method to the madness where after exploitation, the first right is to the cost of extraction. And then there is the concept of a profit petroleum, which is shared with the community and the person who's taken the risk of exploring. And then I'll take my through that entire procedure also. There is a
It's not relevant for the purpose of this.
it will be relevant to the extent of to address the question of whether ultimately minerals are minerals. They are underneath the land. Until we monetize them, they are just a potential. Now, do we want them to remain as potential, or do we want to exploit them for the growth of the community? And I don't mean exploit in the manner of like the Britishers did. No, I mean in sustainable manner, where it is for the larger good of the community, and monetization of the minerals for the larger good of the society, and whether it is at the village level or at the community or the national level.
Because, Mr. Kohli, that would not be relevant for the purpose because we are now in a PIL. Correct. So in a PIL, we are just examining the act and rules. So what happens thereafter? The regulation part that will be taken care of by the appropriate government. So we don't have to really go inside that.
But there is one little difficulty that comes through. The first, then we come to the next question, which my learned friend had correctly raised. If I was to just and keeping, I believe my lords do have a separate bench after lunch. I'll take only 10-15 more minutes to allow 15-20 minutes to the learned AG, and then we can continue. And this is just my opening. I'm just laying out the contours. So 371A, my lords will have to construe several aspects of it, and to also see whether my act actually impinges or requires a legislative assembly's consent, and absent their consent, do they get the power or competence, or is 371A an independent source of power aside of 245, aside of the lists, and the subject matters listed in 371A allow them competence? That question will consider. Coming to the second part of that order, which is on of 14.2, which is whether in a PIL it would be appropriate to quash and set aside the said 2012 regulation and 2012 rules for the lack of legislative competence. Now, my learned friend was right in pointing out that judgment relating to para 50. If we'll have that judgment for a moment. The answer to the question which my learned friend raised lies in that para 50 itself. If Manoj will have para 50 of that judgment, I believe my learned friend had handed it over, Manoj. Manoj will have para 50 for a moment. No, it says the principles evolved by this court in this behalf may be suitably summarized as under. Now, my learned friend went to 11, which says ordinarily the High Court should not entertain a writ petition by way of a public interest litigation questioning the constitutionality or validity of a statute or a statutory rule. Now, Manoj may come back for a moment to sub para 1, 50 sub para 1. But straight away it says the court in exercise of powers under Article 32 and Article 226 of the Constitution of India can entertain a petition filed by an interested person in the welfare of the people who is in a disadvantaged position and thus not in a position to knock the doors of the court. The court is constitutionally bound to protect the fundamental rights of such disadvantaged people so as to direct the state to fulfill its constitutional promises. Alongside, if Manoj will have 5 for a moment. 5 is Manoj the important one, which says when the court is prima facie satisfied about variation of any constitutional right of a group of people belonging to the disadvantaged category. It may not allow the state or the government from raising the question as to maintainability of the petition. Now, Manoj, where the court is prima facie satisfied about variation of any constitutional right of a group of people belonging to the disadvantaged category, Manoj, 371A relates to a group of people. It is specifically inserted because they are disadvantaged and they need protection. And Manoj, the contest really is if there is a variation in their constitutional rights. Now, Manoj, to that extent, on the maintainability of the writ petition, whether Manoj in a PIL such as this one, the court is able to, Manoj, or has the ability to decide, or Manoj, the jurisdiction to decide, Manoj, my lords will have to consider this judgment, and Manoj, there are many others which Manoj delineate this, Manoj, on whether it will be possible or not. More importantly, Manoj, my submission is that the real question over here is not, Manoj, whether it's maintainable because of, Manoj, it's a PIL. No, the real question over here is Article 131. If Manoj will have 131 for a moment.
That's why we started asking you a question that you are not disputing it.
Manoj,
The legislative competence of the state.
131 doesn't relate to the legislative competence of the state. Manoj, it is to the jurisdiction of this court to entertain this kind of a contest between, Manoj, where the contest is directly between my competence, the center's competence to enact the law, and Manoj, the right of the state to, Manoj, where the state feels it has a competing right to enact on the same, Manoj, subject.
That will give rise to clause A, issue arises under clause A.
Yes, Manoj, directly. And Manoj, may please have 131 for a moment, Manoj. Manoj, directly on clause A, which is the contest between the government of India and, Manoj, the state. And please see, Manoj, how the opening of 131 is.
No, that's why we are again asking you. You see, there is a oil field regulation of 1948.
Yes, Manoj.
You did not exercise your power. It's not the case of the Union of India that we wanted to have a prospecting effort and it was negated by the state of Nagaland and therefore dispute arose. There's no dispute with that.
No,
You
Manoj.
barely say that till one point of time you did the exploration, you gave the benefit.
From
to the
78
people.
onwards till 94, no, I exploited.
That's okay.
ONGC did.
That's one part.
Yes,
But then came the State Act.
Manoj.
State Act. After that, the central government did not exercise its power. So therefore, there is no dispute because that's why if it is 131A,
Yes.
we would have washed off our hands.
So
he's
not that,
disputing.
I wish
Therefore,
that to happen, but that is a barrier which they will, when they come over here, they will have to. Manoj.
Because even when this PIL was taken up 2015,
Manoj.
then also nobody raised this question about the court entertaining this PIL vis-a-vis 131A. We also formulated in one of the orders of the court as to whether 131A is an issue within the meaning of 131A.
Milon,
Nobody raised this issue that 131A would be involved.
Milon.
So therefore, we gave an opportunity to both of you to raise this issue, but it was never raised. 131A was a specific order of the court.
Yes,
It's under
Milon, I,
131.
yes. Milon, Milon,
But
in
that was
that
never
respect,
addressed.
Milon, it's to be fair, Milon, in our affidavit, 131A doesn't find a mention. Milon.
It's not even that.
I
You
am
see,
not able to
previous-
raise it directly also because by filing a petition. I can't do that too. But
Because-
even,
Because once there is no dispute, we can't create one.
yeah, it's not, it has to be that would be, that has to be this side of the
That's why
petition.
we started asking you that specific question.
No,
You did not have the effort of oil exploration, which was thwarted by the state government,
no,
and therefore a dispute. So therefore, this dispute is not there. It's an arrangement between the central government and the state government. They formulated, they went ahead with the exploration, and then the central government kept quiet.
no, in fact, they came out only in 2012 for the first time. When they came out with the regulations and they issued the first permit. And Manoj, that permit has since been stayed. There is no exploitation of any resource by the state government also, or by any Manoj, the person appointed by the state government, which has been given a prospecting license. Manoj. So to that extent, Manoj, it's a status quo. And in my very humble submission, Manoj, a great loss to the community at large. Manoj. So the issue needs to be Manoj, addressed. There is no doubt about
Because that is by way of an interim order of this court.
Manoj.
Even the central government does not come forward and say that please vacate that. Because
No,
it will
but-
be between two of us.
Because I'm not ceding notes to their jurisdiction. I'm not saying that the acts are proper. I'm not saying that. No, I'm in fact saying that my act is the proper one which will apply. But my notes are right that I haven't asserted my right in to that extent that this is the act which will apply.
Just
I'm so sorry.
my brother was
I'm so sorry.
going through this the state act,
Notes.
and my brother has also compared the definition of oil field
Notes.
in your oil field act, oil field act 1948
Notes.
and the state act. It's a replication.
It is. In fact, Manoj, I'll demonstrate. One of my endeavors would be, Manoj, I'm so grateful for that, Manoj. Not only is the definition of oil field, Manoj, identical, the process, Manoj, that we have devised in terms of the PNG rules, petroleum and natural gas rules, where, Manoj, once a license is given, where there is the exploration cost, which is, Manoj, first to be taken by the developer. Then there is the concept of a profit petroleum. And then there is Manoj, the allocation between the government or the landowner and Manoj, the developer. All that is replicated here. The words may be Manoj, either replicated or slightly different, but the concept is 6 by 6. There is no difficulty there. So Manoj, essentially, what the government of Nagaland wishes to do is they wish to decide. And Manoj, which the government of India may not really be averse to, because that is why Manoj, that high-powered committee has been set up. The government is only interested in making sure it's done equitably, and Manoj, the development of the resource takes precedence rather than the distribution. Because Manoj, until there is development, there is no distribution. So Manoj, it can't be that you put the cart before the horse, Manoj. And Manoj, I just took instructions, Manoj, to what falls from my loads relating to Manoj, the dispute and the possibility of 131. I'll have to take instructions. My difficulty is the officer here may not be the competent authority to give those instructions.
There's no document here to show that there is a dispute.
Yes, I'll need to take instructions on that, then maybe complete the in terms of an affidavit over there. Or
By and large, the impression is that we old Hindi saying, "Miya Bibi Raji."
in fact, given Manoj, the sensitive nature of the state, it is not anybody's attempt or desire to disturb anything. Whatever has to be found amicably. That's the endeavor.
Okay.
Yes. So I will need two indulgences from my lords. One is to take instructions and if need be file an affidavit relating to this. And the second is if will allow me the privilege of filing written submissions, which will lay out how we.
Let us see how we proceed. Those,
Then I'll file the affidavit first and written submissions later.
if,
If required, before the next hearing, or during the next hearing, if were to allow me, I'll do it.
that will be at the end of the day.
At the
When
end of the day,
pass orders,
then
we'll
I'll just give a
consider that.
two-page flow of arguments, how.
So we'll consider your submissions
Uh,
when we pass orders.
Yes. These
You
were
complete your part.
I'm sorry,
You can proceed and complete your part. You
No,
said
ma-
that you take 10 minutes more.
that was only on the opening part. I'll have to take my lords through a lot of judgments and the detail for a final hearing to be concluded. That will be my submission. As my learned friend said,
No, because he's also raising the issue of the maintainability part to be addressed first. So that will have to, once a preliminary issue is raised and
that
reference is made
preliminary
to
issue
the
will have
earlier
to be
order,
decided first.
we have to be taken, it has to be taken up first. That's why I said that these two leave which you are wanting would be subject to further orders that we are passing.
To that extent, then may allow me some time to file an affidavit, which will if the government so desires to place the issue before this honorable court. Because at
But
the
still, that would be on merit.
No.
That will not be an issue with regard to the preliminary issue of maintainability of a PIL vis-a-vis the power of the court to question, set aside a legislative act or a rule.
For
there
that,
is-
I believe, sorry for interruption.
Yeah.
Further instructions may not be required so as to decide that issue because it is a question of law. So without instructions also that can be decided. That part.
Yes,
Sorry,
in
correct.
my humble submission, that jurisdiction vests.
Okay.
Which we read that judgment in clause 1 and 5. It clearly says when there is a variation of a constitutional right, this court will entertain, and this court will. So, to my mind, the maintainability issue is not limited only to whether in the PIL the PNG regulations and rules can be considered. It is a larger question whether under 131 this can be the contest which this court will determine. So both of them go together. I'm only saying to make sure that both of them are together. May allow me time to file that affidavit if the government so desires, and we can then argue it fully on the maintainability issue relating to this.
At the cost of interruption, my lord,
Yes.
this issue of 131, your lordship had asked us right in the beginning, and we had a few hearings on this, and we established that this would not come, and there was no opposition from them. Now, towards the end, they want to again take up these issues. This was never their case. Even in the questions they have put as by way of their submissions, never raised. I had appeared. Your lordship specifically asked, can we take it up? It is up to them. They want to take up these things.
I'm not able to answer what happened prior, but I can assure my lords that it won't happen again.
Okay. So in that,
No, in fact, if Manoj will, I'm so sorry, Manoj, if I'm not interrupting. If Manoj will just please see the order of 15th of March 2021. No, this issue was specifically raised by the government Manoj, on 131. If Manoj will have that for a moment. 15th of March 2021. I read para 2, Manoj. And loads are with me. No, it says the learned senior counsel for the respondent number 8 has submitted that the facts based on which this writ petition is filed prima facie discloses existence of a dispute between the central government and the state government regarding the rights of exploration and extraction of petroleum and natural gas in the state of Nagaland. Accordingly, he submits that the provisions of Article 131A of the Constitution of India would apply on the issue raised before this court. All sides have no objection if the said issue is heard as a preliminary issue on maintainability. I'm so sorry. Yes. That issue is there. No, as I understand. As I understand, Lord, subject to correction, Lord, what falls from my Lord today is that there is nothing on record to show the dispute. Lord, while the order is there, but there is nothing on record on paper to show that this dispute has
No,
been.
there are. It is within us. We have it in our sleeves. There are materials, but we found that the government of India is not pushing it hard. They are pressing it hard.
Yes.
So there are materials in the record. There are materials, but no issues were raised any time.
May allow me to file a better affidavit in that case.
Complete.
Yes.
Just a minute. Mr. The advocate general would like to make your submissions in this preliminary issues on maintainability.
No. In fact, he,
Then after that, we can hear Mr. Jamir on the his reply arguments.
as far as 131 is concerned, my lord, he has to first establish how 131 is established in the facts and circumstances of the present case. First, he has to establish that. You cannot just say 131, which means any dispute will just go on to Supreme Court. It will be flooded with this level of litigation. So he has to first establish that. And I had made detailed submissions on the basis of facts and law. It was thereafter, it was decided that we will go ahead. They did not object thereafter. When the matter was decided to be contested, they didn't object. They accepted the finality of this honorable court's order, and then they were taking date after date, date after date. Now in the last minute, he wants to come and rake up an old issue, which according to me has been settled. Even for the sake of arguments, my lord, if he wants to take up that issue, let him argue his full case and also take up this issue also. That would be fairness. My lord, each time they are changing. They started the arguments last time. They gave us the list of their arguments. They never raised this. They submitted to the jurisdiction of this court unconditionally. They gave their submissions. They never raised it. So in the light of these type of allegations being made that the villagers are not competent, I don't think it's fair on any council to make the statement as far as the people of Nagaland are concerned. It's not that only they are educated, central government. People in tribal areas are people with wisdom. Forget the education level, they are educated also. We have more than 80%. So this type of comment should not be made. Britishers can make this comment because they were exploiters. Central government is a central force, federal government. Even the judgment, 9 judges, which your lordship was talking about, judgment has been given today. That has been passed today, which they were quoting last time.
Oh, is
Where
it?
they yes, where they have said that the state has the right to tax on minerals, etc. Only one dissenting, that has also come. So if he wants to make those submissions, in all fairness, my lord, he can keep those submissions, but let him complete the arguments. It won't be fair that the learned amicus query makes submissions, then they take time that he is not here. And before that, they already made their submissions and they want more time. You can't just wriggle around like this. This is not proper or fair to the court. They should be fair. Even that day when the case was adjourned, they didn't have the courtesy to inform us that they are not coming. At least a small information. We are not so small people. Maybe we are not very big people. Courtesy demands whoever is coming from whichever place, they inform us. They don't.
No, but that is over. We can't.
I am just saying they cannot take everybody. They cannot take. They may take us for granted, not the court.
That's okay. But
Yeah.
what is ended on the day ends. Mr. Balgopal, what was that civil appeal number of the Supreme Court which has been decided today, 9 judge bench?
1988. Civil suit 2 of 1988. That
Civil
is
suit
with
2 of
regard to the border
1988.
I believe, yeah. Learned Advocate General is appearing in that case, so he'll be in a better position to confirm. But if my memory doesn't fail, it is civil suit 2 of 1988.
88.
That is pertaining to the border dispute between Assam and Nagaland.
Okay.
That is still pending.
No, that 9 judge bench yesterday. The last occasion we put up.
Yes.
That
9
one.
judge bench.
Mr. Bhagopal, what is the number of that case?
I'm just giving to your lordship, my lord.
Lordship, with due respect,
It is given here. I just come to 2 lines on it. State power to levy tax on mineral rights not limited by MNCR Act, royalty not tax. Supreme Court holds by 8:1.
No, what is the civil appeal number?
No, that's
that I can-
I will
4056
just pass on the civil appeal.
1999.
Huh?
4056
4056
of 1999.
civil appeal number.
Yes, no, CA number.
This is the oldest judgment pending as far as 9 judges bench is concerned. Such a long time. This has come on live law, all these things. I can just send it to my colleague there. They'll take a printout and bring it to your lordships.
Okay.
They will do it during lunchtime.
Mr. Kohli, we told you we have certain things up our sleeves.
Yes, Manoj.
Uh, I believe you have a copy of the written submission made by the state of Nagaland.
Yes, Manoj, we were served a copy, Manoj.
That is on record, my lord.
Yes.
That has been given to the amicus query also,
Yes.
and also to Mr. Jain.
So now you will find that there are 4 queries. There are reference to 4 queries
Manoj.
which was raised by the Ministry of Petroleum before the Solicitor General of India.
Manoj.
And the response to that is there. If you don't have a copy, you can take this.
Manoj, I have it.
You
I
have it.
with me. Yes.
So there are 4 queries. And the Solicitor General of India has opined that the legislative competence to pass that order is available. So therefore, 131, there is no dispute whether you, if there is a stand of the Solicitor General of India, so far as till the situation and date is concerned, because you are new, you may not be knowing of that.
Because I've gone through that
you
opinion.
have been instructed. Okay. So therefore, as on date, we have nothing on record to give you that leave to file an affidavit to bring on record if there is any dispute.
Manoj.
Because this written note was submitted long back.
So this was by the state.
15. This is in sometime in 22, I believe.
I have placed down this, my lord.
So therefore, this was never in dispute. No questions raised.
Lordship, by order dated 4/8/2022, liberty was also given to all the parties, especially the central government, the private respondent, to file their affidavit by 22/8/2022. Order dated 4/8/2022.
In this regard, the court has already indicated in the order dated 15/3/2021 that the issue of boundary of the state is still covered by 131A. There were those dispute questions related to facts. Also, Assam we had excluded because that exploration like it included a part of Assam. So Assam is excluded. Therefore, the 131A was excluded by implication.
Next para.
That was because that is a dispute between 2 states. Mr. Kohli, that exploration right. A part of that right, there was an allegation that it infringed into the state of Assam.
Manoj.
So, if that would have been, so therefore we excluded that. So far as state of Assam and Nagaland is concerned, state dispute that is no longer alive.
Yes.
The second part of the Union of India, with regard to that Article 131A, so far as all these 4 queries are concerned, if you have a copy of that, please. You will find that query number one is whether the resolution adopted by the Legislative Assembly of the state of Nagaland is in line with the provisions of Article 371A of the Constitution. That is answered in affirmative. Second is,
was whether the Nagaland State Assembly is empowered to make laws or rules in respect of ownership and transfer of land and its resources, including mineral oil.
so this is answered in to that extent, the resolution is valid and in consonance with Article 371A.
Manoj,
So that is the Solicitor General. He speaks for the Union of India.
no, that's an, no, no, I will, no, I see what falls from my load and no, I know where this is
No,
going.
that's why we said when we
No,
made a statement earlier,
Yes, no,
there's
I
no
follow.
apparent dispute
Yes.
with regard to that.
No, we'll
Then
have
you
to-
see now number two query is also in line with Article 371A.
Yes.
That's the answer.
I've seen those answers also. Manoj.
3 and 4, you see,
Yes.
when in answering this question, query number 4, that's why you see our questions were
Yes,
on those,
On those.
ownership and transfer of land and
Yes.
resources. My brother had put a specific query on that.
yes.
So this is 4. And in 4, by referring to this, all this. now, So in page 5, that has been answered. Again, affirming the state of Nagaland's power to do it.
No, no, no,
And you see, we'll tell you, once you are there, we'll tell you, there's something more.
Act is valid.
I'm sorry.
That if that act is stated to be valid, all the definitions like oil field, land and its resources got included into it.
Yes.
Land, they have included everything.
No, so no,
Well,
I-
just
yeah,
to
I fully
apprise you,
appreciate, no, Yes.
say, for example, what is the definition of land? Land and its resources includes minerals, mineral oils, petroleum, petroleum products, every other product of mines, including forest and forest products. That act includes everything.
no,
You come to page 178 of the brief.
of the writ petition, no,
Yes.
the per 178.
It's annexure 25, if you are getting it through that.
Petroleum minister. Chief Minister.
You see, this was from the highest level. You look at the name of the signatory,
I don't know. It's-
and then you look at the name of the addressee down below of that letter.
Was in 2013.
This was raised in 2013. After that, something happened and the government
Serious,
remained silent.
serious constitutional implication. Serious constitutional implication.
Para 2 will make it very clear of this letter.
It's like the government is disputing it. Government is
They raised this issue but kept silent.
2013.
2013.
That's why
Then
I said-
this opinion of the Solicitor General of India, it might be later.
Yes.
And that is the basis why we said Miya Bibi Raji.
Look, as I said, look, my instructions are because of the sensitivity of the matter, look. But I follow, look, what falls from my load, that there has to be a clear stand of the union on whether, look, they're accepting the opinion of the SG or look, they are going by this letter at 178. And look, in fact, in our affidavit in response, which was filed in 2016, that is in line with this letter of 13 minutes, not in line with the opinion of the learned SG minutes. That in fact, notes in my affidavit, I've clearly said that they don't have the competence and this lies with the union insofar as oil fields are concerned. So notes to that extent not clearly
That's why by a judicial order, we can't give you that leave to make an affidavit to raise any point. That would be.
Look, but I will have to bring out the stand of the government on this notes clearly, because if my lords were to go, then look what the opinion of the learned SG is an opinion. Now, I'm not instructed on whether the government has accepted that opinion or not.
That's why this query was by the Minister of Petroleum.
Yes.
The Minister of Petroleum is questioning this, the act.
Absolutely.
And then Minister of Petroleum went to the Solicitor General, and Ministry of Petroleum got it. So it's not a private
It's not.
opinion.
It's not. No, the Ministry of Law also got it, but no, whether the government has accepted it or not will be the question. So
The government has, you see, in the affidavits, the government has not said that is there, and this, if this written argument is on record.
yes, so my
The-
response to the written argument is not there.
Mr. Kohli, what happens is that we are in session of this PIL since 2015.
I follow that.
One has to bring it to a close, whether, so the question of allowing you to file an affidavit, again bringing the reply affidavits, that would again prolong the,
Mine is a reply affidavit. May view it.
no, if you take a new stand, we have to give opportunity to all of them.
My stand will remain consistent. May please see 2013, the Honorable Minister articulates a stand which reflects the stand of the Ministry of Home Affairs. Then may have for a moment my affidavit which I have filed. Which is the
No,
counter
we have
that
taken note of that. You are merely saying that that it is contrary to your. You dispute that, you say it's contrary. That's the only language you use.
no, in fact, if will have para 4 of my just 2 paragraphs, para 4 of my counter. I'll just read 2 paragraphs, 4 and 5. My lords are with me.
Yes.
No, it says in light of the above direction given by this honorable court, the present affidavit is filed on the issue pertaining to competence of appropriate government with respect to enactment of laws pertaining to development of oil fields and minerals and oil resources, petroleum and petroleum products which would be applicable to the state of Nagaland. That the present affidavit is limited to the issue which deals with source of power and legislative competence on the subject of development of oil fields and mineral of oil resources. The answering respondent reserves its right to file the para-wise reply in respect to on merits in case the court does direct. It is submitted that this honorable court, by its order dated 8/10, had rightly observed that the subject enumerated in list 1 of schedule 7 are within the exclusive domain of the legislative competence of the union. In accordance with Article 246, the exploitation of oil and natural gas is a subject covered under 53 and of list 1, and therefore Parliament alone has the power to legislate laws on this subject. Accordingly, the ODRA was enacted by the Parliament to regulate the oil fields and development of mineral oils, which Act extends to the whole of India. Section 5 and 6 of the ORD Act grants power to the central government to make rules in respect of mining leases, licenses, and development of mineral law. In exercise of the powers conferred by 5 and 6, the PNG rules have been notified for grant of regulating the grant of exploitation license and mining leases in respect of petroleum and natural gas and conservation or development. Therefore, this is important where it says, thus the competence to legislate on the subject governing the exploitation and production of oil is exclusive to the union government by virtue of the Constitution of India. Any law, regulation, or resolution passed by the state government on the subject which are within the exclusive domain of the union is against the provision of the Constitution of India. So, while I say it, I don't say it as directly that the PNG rules and regulations both are bad and therefore beyond the competence of the state government. While I say that, not as directly, possibly. But the issue is raised. Now, this is not in line with the opinion of the learned expert. And that will also be the question of the attorney-client privilege, whether I accept it or not, whether the government accepts it or not, the other side can't rely on it. And the other side can't say that I'm bound by the opinion. That is for the government to decide whether they are bound by it or not, or whether they're accepting the opinion or not.
We have deliberated and we are of the views, and since we are holding up this PIL since it's a 2019, 15 PIL. Sit on the merit also, because the question of maintainability being is one part, but since we have hold on this PIL for quite a long time, we also go on merit, and then both things we decide.
It's together.
Because ultimately, this, after so many years, to decide a preliminary issue and then go to final hearing, because this is a special bench constituted.
Absolutely.
We are tied up with this, and it disturbs all our other rosters.
My apologies for that.
So this, you see, intention is not to seek your apology. It's just
Well, I'm-
besides the point. But the fact is that we are a special bench.
Yes.
So we can't devote more time for this bench and then have it constituted time and again and disturb the roster, because here we have a unique situation where we both travel out of to the outlying benches. So therefore, everything is not within our control. So we can just speak for the week or two, but not beyond that. So after that, we don't have the competence to.
Lordships, in that case, on the last occasion, Lordships has fixed 30th
Huh.
July,
On that day, you will not
where
be
I
there.
will not be
Yes, yes.
available, and that I have expressed my difficulties.
Yes, yes.
So I was going to request Manoj on 30th. I'm in some personal difficulty. If Manoj could accommodate me by
No, because next, after
In
that,
that
we don't have our
case,
roster. We
Lord
don't
Chief,
know about that.
Uh, a date will
because
be
if my thoughts are
fixed,
going on the
and
merit.
if it is not finished in the first one session, it can continue for the second day, 30
No,
like that.
That's okay,
I
but
would
but
suggest
the-
to get a fixed date starting from a Monday, so that we can continue for the entire week also. Doesn't matter,
no, that's, we can't say that.
That-
We can't say that
It's not
because
possible.
because most of
this-
the councils are from outside, and it is more preferable to be physically present.
because
So
Instead
this
of,
matter will require physical arguments,
virtual,
Manoj, that
all
I'm
this,
quite clear
because
about.
lot
So
of
I mean,
inconvenience are
may not
created.
really be the most appropriate to have it virtually, because at least I will not be comfortable Manoj doing it. Okay, I'd rather be here.
no, you're right. If it's a issue which involves questions of law, a physical
Absolutely.
hearing is more
Yes.
appropriate, but now the trend is for this virtual hearing, so we can't say no.
Manoj, I was speaking for myself. I was only speaking for
That
myself.
is a sort of a preferential treatment.
Yes.
Otherwise, in case of unavoidable circumstances,
And Manoj,
We have a difficulty on 30, we
Manoj,
fix it on 1st and 2nd of August. Because after that, we don't know about.
Manoj, may I just make one,
Let one hearing be held, my lord, on 2nd of August. Let it be.
no, I was only
One
going to,
date can be fixed. We have adjusted a lot with them. Let them also come forward and as a support. It may be kept on 2nd August.
No, 1st and 2nd, so that
Lordships,
2 days we can,
my
you will not be. there.
journey will be up to
No,
second.
because now it is for the, for Mr. Kohli and then Mr. Balgopal to make his submissions,
Then that's okay.
and We'll
Let
accommodate,
them complete their, my lord,
we'll accommodate your inconvenience. We'll accommodate you because
let,
Look, I was going to, look, the sequence in which look, we will argue, if look, could just indicate that also. And look, we could come with written submission that
no, because you see, that is your prerogative. We won't say how much
yes, sir.
how much you'll argue, how much time we will give you for
Yes.
argument. We are not saying that, right?
I'll take notes if we have the morning session as we have today. I'll take 2 sessions notes.
So first and second can
Look,
be,
First and second, I mean, I'm so sorry, Manoj. I just got introduced into this matter and I don't Manoj, mean to appear to be difficult, but first and if Manoj could accommodate me, Manoj, on 19th and 20th or
that's a bit too
20th
long
and
because you'll
21st.
forget.
No, because I'll finish in those 2 days, Manoj. 20th and 21st, I'll finish. I have no difficulty.
Well,
I'll
keep
take
it
those
on
sessions.
first, my lord.
I have a difficulty. It's very less, very thin hair. I can't retain.
I, because my loads knew more about the brief than possibly all of us together.
So therefore I can't retain. It has to be faster because otherwise if we keep it and after a long time we.
No,
tend to
I'm only
forget.
seeking August, no. On 20th and 21st, no.
No, no.
Subject to my load's convenience, no.
Too long because we can't say. After second we can't say it. The master was to be fixed. Because we don't, you see, on the last occasion also what happened was, since you did not come, and you could not because the first time when you came,
Yes, no,
then we were not there. The bench was not there.
yes.
So thereafter after it was adjourned, next time also it was adjourned. So therefore, in the process, we had to request Mr. Jamil to make his submissions for the third time.
No,
He had to open up everything and then on the to just recapitulate.
no, I'll happily
was
take
that?
that burden the next time. No, I don't have a difficulty with that, and I'll take 2 sessions, no, and I'll notes finish.
My lord, keep one session on August 1st. So that the continuity is there. One session, keep it on first. Then your lordship can decide on that day.
No, we are
Because
just
this-
accommodated because he has personal difficulty. Once he's saying about personal difficulties, we are trying to just see.
My lord, we also have Assam Nagaland border dispute. All these things are coming. In spite of that, we are saying that first is okay. If your lordship wants second, second also we will take.
Fifth Monday then?
No, my lord, I have border dispute, 5th, 6th,
Oh,
7th.
okay. Fifth is a border dispute.
Yeah, 5th, 6th, 7th.
And that takes priority over this dispute.
No, definitely, because that is before the Supreme Court. It's the suit number 2 of
Yeah.
1988.
Yes,
One of the oldest pending suit.
and the witnesses come much before that.
No, on 20th and 21st, no, I can finish, and then no, my learned
That is
friend
too
may.
long. We can't retain like that. If the Advocate General is on 5th, 6th, and 7th in the suit, then on 8th of August.
Look, 8th I can do notes, but 8th note I may not be able to complete. On
It's okay. We'll then fix according to our.
No, then we'll have visibility ahead. Notes 8th it is. Notes.
Fix one day, my lord, so that we can see how much it's done.
8th then.
Very well.
Advocate General. Okay.
When is the border dispute?
Model dispute is on the 5th and 6th.
What is the date? I think it's not 7th and 8th. No?
Not on the 30th.
No. In the last one, we have the names. We just add Mr. Vivek Kohli as senior counsel for respondent number 8.
Sorry, Lordship, can you bring the microphone to make it more audible?
No, the names are already there in the last order. We
Yes.
just add Mr. Vivek Kohli's name as senior
Grateful
counsel for
names.
respondent number 8. So that's what, that's the first para. The submissions of the, we have heard the submissions of the learned amicus curiae, assisted by Mr. A. Ozukum. Full stop. He reserves right to reply. Next para. The submissions of Mr. Vivek Kohli, Learned Senior Counsel, appearing for the respondent number 8 remains inconclusive. Most of the submits that the next date is fixed on 30/7/2022 when he has on the said date he has some personal difficulties and therefore he pays for an adjournment. Adjournment on 30/7/2024. Say prayer is considered and allowed. The next date of the matter is fixed on 8/8/2024. Before that, you might one name. We are conscious of the fact that there was a there was an order to hear the matter on the maintainability of the PIL. However, as there's already been a delay in the adjudication of this PIL, I propose to hear the matter on merit as well as on maintainability. Next one, please. List on 8/2024, subject to availability of the bench.
Lordship, the virtual mode may also be kept open as an option. Of course, so far as I'm
No, it is
concerned.
already there. Now
I
we
will
have
make
the
it,
rules. It's
got it.
already there. You just make a request, we'll commit that. That will come to one of us. who
So
is
far as
available.
I'm
So
concerned, I will make an endeavor to be physically present.
you make a request, we'll consider. The court counsel will place it before us. Even if we are not there, we'll be, it will be placed before us. That's no issue. But we are making it clear that subject to availability of the bench here. Because next week we don't know.
Today I had two more matters before the Guwahati High Court. I got it listed at 2 o'clock. Otherwise, I would have come there and appeared. I thought everything would clash. So this was the only alternative.
Oh, that's okay. Once we have the technology, you can avail it.
Technology cannot displace presence. Physical presence.
I just wanted to clarify one thing. If what my learned friend, the learned AG felt was my remarks were to the economic ability of the region, not to the natural ability which is God given. That everybody is equal. There is no village in India which can develop an oil field by themselves purely because of economic
That's
reasons.
okay.
I didn't mean to offend, and I mean no disrespect to any people of this country. We are all
No, that's
equals.
okay.
Lordships, since Lordship has arrived to an opinion that the matter will be heard and meted. So, in my respectful submission, Lordships, the primary issue and the relevant issue will be the lawmaking power of the union and who has the legislative competence to make the law, who do not have. So, I believe we should confine to that area only instead of going to so many irrelevant issues. Because if we are to open,
No,
it
no,
will open the
Mr.
Pandora's
Amir.
box and so many intricacies.
Mrs. Amir, you see, it's a PIR, number one. So therefore, essentially, we are not going deeply into that pleading part. That's just one. Now we are, as we have seen everything, we are also pitted up against 131 clause A.
Yes.
For that, we have shown whatever the materials are there. Now, if from the number of submissions made by all of you, if it appears that there is really no dispute at all, so merely because you write a line, just like in a writ petition, you say the writ petition is not maintainable in a affidavit in opposition, doesn't make it a preliminary issue. So therefore, when Mr. Kohli said that, please make a clarity as to what would be the contours of the argument. Then we said that we will go into merit also because this is a matter of 2015, PIR was registered in 2020, and therefore we also go there, and therefore
So far as Article 131A is concerned, my learned friend has referred to an order of 15 March 2021, where there is a line that all the councils do not have the objection agreed under position. Unfortunately, I was absent on that day, but by reading the entire sentence, it appears that I have also given my consent to that.
no,
But I was absent on that. Secondly, Lordship,
not that. You see, Mr. Zamir,
up to that order.
no. You see, what happens is that 131 was only in respect of the Assam-Nagaland border dispute.
Yes.
You are not entered into any other space.
Yes. No, what I'm trying to project, Lordship, up to 15/3/2021, there is another order on 4/8/2022. There, this honorable court has already virtually decided that issue, 4/8/2022. And that day, this issue which was there in the 15/3/2021 has already been discussed and then virtually arrived to a finding on 4/8/2022. With regard to the 131A.
But my only submission would be, the consent of the amicus may not really be relevant for determining what is the point of dispute. The amicus, in his capacity would be to assist the court.
I'm
Not
trying to
close
assist
to-
the court.
We already know the contents.
Yes,
Correct.
yes.
Know the contents.
We'll try to keep it as, concise and relevant as we can. Of course, our abilities fail us
Because we should
sometimes.
not lose the track.
Yes.
No, that's why we are not now going here and there. We are starting the
Yes,
argument on
Lordship.
merit. So everything which comes,
As far as possible,
take it
I'm carefully trying to take the proper
I
approach.
understand you are formulating
Without-
because so that the matter is heard in a
In a systematic manner.
sequence.
Then
So there's no issue with that. But
just to
we
assist this.
already have a meeting of mind as to what you call the matters, because whatever is irrelevant will tell you.
Of
that
course,
it's
of
irrelevant.
course, of course. Deeply obliged.
Obliged, Lordships.
Admission today. Well, we need to file affidavit in the matter. Well, I prefer 7 days time.
But I'll have to issue, we'll have to issue notice first.
It had come for the admission.
Huh.
Notice was issued.
Oh, notice was issued.
Yes, it was issued.
Just
Preventive detention matter, it's a habeas corpus matter.
Some instructions have come.
Just see the class
The
order.
a report of advisory committee, all these things have
I
come.
don't object.
Lordship.
I was just seeing the last one.
Yes, Lordship.
Is it under the NDPS?
It is under the PIT and
PIT and DPS.
P-
Okay,
PIT,
now-
PIT,
now-
PIT and DPS, Lordship.
Okay, now you get it. Now I get it. Mr. Y.S. Manan, learned counsel for the petitioner is present. On the prayer made by Mr. D. Nath, learned senior government advocate. List on, give a date after 7 days. List
But,
on so it's
can it-
unable
Can it be on fifth,
the state to file affidavit in opposition in the matter.
fifth, on fifth,
Fifth.
Lordship. By then we'll file the evidence. Lordship.
Much obliged.
You're there for,
For
okay,
CGS.
this,
1, 2, and 3, I am appearing.
That's point
One
number 4.
I forgot. Keep it, CEC for respondent.
Lordship.
May I please, Lordship? I would like to mention item number 4, Lordship.
Yes.
The learned counsel is that is appearing in this case also due to some domestic program today here. And he was here but left at 12, so it may, Lordship, come on a 6th August.
Only problem is, program, okay, okay.
Domestic program, Lordship, held in during the daytime, but he was here but left 12,
It's okay,
6 August, Lordship.
because once the word domestic comes, first thing which comes to the mind is domestic violence. I'm sorry. Item 4, okay, on the prayer made by counsel for the petitioner, list after a week.
6 weeks,
Huh?
6 August, Lordship, if possible.
6th August, you want a fixed date? 6th August is a Tuesday,
Yes,
no.
Lordship.
7th August.
No.
Okay,
May it please your Lordship. Lordship, I am appearing on behalf of SK Nargis for item number 3, Lordship. One of the distant relatives of the petitioner informed us he met with a serious accident. So Lordship, we are unable to confirm if he is still alive. We could not contact their family, Lordship. We require some time.
the, see, both says a representative of the prayer made by counsel for the petitioner, list after 2 weeks. There are also.
Item number 11 for motion, supplementary list.
Record was called for. It's not received.
LCR is not received.
Yes, Lordship.
Okay. Please before any other bench without one of us. Yes, Pranav. I can't take up this matter.
Yes.
Item 12 for orders.
In that earlier order.
Yes,
you just add in your prayer that the LCR is not yet received. So that LCR can come in the next day.
It's listed before any other bench. Meanwhile, LCR can be.
Yes, Lordship. Lordship may issue reminder.
In the meanwhile, LCR has called for the LCR has directed the call for. Item 12.
Item 12 for orders.
Extension of time, Lordship.
He could not appear.
Yes, Lordship. For capturing her, his biometrics, Lordship. Courts directs to appear before the concerned SP.
I'm sorry, Lordship. Item 12. I could not appear, Lordship. Page 5, para 5, Lordship, kindly state.
This is not a disease not to appear before the SP border. Acute gastritis.
Yes, sir.
Lordship.
Is it a valid ground not to go before the Suprema Police? You can go to a doctor, by that time you can reach the Suprema Police. How much time it will take to
15
before the
days.
police?
15 days time.
7 days time maybe allowed.
15
No,
days,
no, no.
Lordship. I have to procure a
The-
certified
yes,
copy,
Lordship.
Lordship.
The time, how much time does the Superintendent Office takes, SP office takes for biometrics? How much time? Half an hour?
Yes, Lordship. More than half hour.
15 days time will be granted, Lordship, because I have to
No, no, no. Why
collect the
15 days time?
certified copy,
go.
Lordship.
You,
Time will be taken for procuring the certified copy.
for certificate copy in my court, nobody has complained that it don't get within 3 days. Two or
But 3
3
days is necessary, Lordship. For Lordship, I want to say at least 10 days time, Lordship. At least 10 days.
7 days. 7 days, whatever illness you have, with all the illness, you will go there. Ah. 26. Heard Mr. A. Sharma and counsel for the applicant. Mr. G. Sharma, Leonard, standing counsel for the Home Department. Mr. A. Ali, Leonard, is standing counsel for the you are not there. No, in this case. From 17, we are not. And Mr. Arthur as well.
Respondent number, opposite party number 6.
Yeah, committed to appealing for respondent number 6. Yes, by filing this interlocutory application. No, but that's it. By an order dated 29/5/2024. This court had directed the applicant, namely Mohammad Mujibur Rahman, to appear before the Superintendent of Police within bracket border, Sivsagar, on or before 26/2024, during the office hours, along with a certified copy of this order for capturing the biometrics of iris of both eyes, of both his eyes, the fingerprints of his both hands and photographs. With conditions attached. Projecting that due to some illness, the petitioner, the applicant could not appear before the Superintendent of Police within bracket border of Sivsagar. Regarding this interlocutory application, comma, the applicant seeks extension of time to appear before the said authority. If there is allowed. Despite objection made by the learned government advocate appearing for the respondents. The applicant shall now appear before the Superintendent of Police within bracket border on Sivsagar. On or before within 6/8/2024. We are excluding those Sundays and all, and their office may not be working. In compliance of the order dated 29/5/2024. The applicant shall produce the certified copy of order dated 29/5/2024 as well as copy of this order before the said authority.
Failure on the
This
part of the
application dates.
failure on the part of the petitioner that interim order will automatically vacated, Lordship. That observation was there, Lordship.
Okay. Page 17, second para. Failure on the part of the applicant to comply with any of the directions contained in the aforesaid two orders. The bail granted to him shall automatically stand vacated and he shall be liable to be taken into custody. This
Obliged.
application stands disposed of.
Obliged.
Let's see. Just after 2 weeks. Answer is received. Just after. It says it. Huh? What's it? Yes.
Daily list item 2.
None appears on call for the petitioner. Both the name of the learned counsel are reflected in the cause list. Next. The petitioner has remained unrepresented and the matter was previously listed on 21/5/2024. Accordingly, it is provided that on the next date of listing, or the petitioner remains unrepresented, closed orders will follow. Next one, list after a week. The date to be fixed by the registry.
Item 5,
Eventually, we have to allow this writ petition.
Lordship,
We have to allow this writ petition.
Lordship,
You look at the instructions which you have produced from the last date.
Lordship, instruction dated, Lordship. You are doing.
19/9/2023.
No, Lordship. After that, Lordship, another instruction has been received, Lordship. Then that was 10/11/2023, Lordship.
Don't think that has been placed before us.
Lordship, can it be on tomorrow or day after tomorrow, Lordship? I have to verify some. Lordship. I have received one instruction on 10/11/2023.
Pass it on. Let us see what is there. Correctness of the inquiry is still the same. Fine.
Enquiry was made only on the basis of his statement, Lordship, and some statement of the local villagers,
No,
Lordship.
that's not the point. The point is that the legacy is found to be established since 1966, uninterrupted. You have the paper, the repetition.
Yes, yes, Lord.
Come to page 64.
Yes, Lord.
The handwritten evidence is page 66.
Yes.
You see in the cross-examination,
Lordship.
all these documents and the legacy has been established since 1966. The same is confirmed by the Superintendent of Police again here. Because if the connection of the grandfather is established, then you have to allow this. Because exhibit K is the document which connects him. School certificate, it connects him to his father.
Lordship. Let me verify once again.
Hmm?
Can it be on next week, Lordship?
Non appearing call for the petitioner. Mr. G. Sharma, and a government advocate has submitted that he is in receipt of a inquiry report dated 10/11/2023. He wants to go through the same and address the court. For which he prays for an adjournment, which prayer is allowed. List after 2 weeks. Date to be fixed by the office.
Item 6.
Next.
Item. Oh, মই সুধিলো না ছাৰক।
Petitioner has been declared to be a foreigner of post 1971, Lordship. Imbued judgment and order dated 15/5/2017. It's on page number 46, Lordship.
How have you connected you with your grandfather? What is the document to connect you to the grandfather?
Lordship, kindly see annexure number 4, page number 21, sale deed.
No, that
The plot of land purchased by his.
that will not help you. For two reasons. Number one, the tribunal has held that you did not prove this document by way of a attesting, by calling an attesting witness. Correct?
Yes.
That is one. That is the strong legal principle where if you have to prove a sale deed, the sale deed must be proved by the person who is the signatory or through a attesting witness.
But
Or if both people are not there, then some legal heir will say that yes, this is the signature of my. The attesting witness will come and say that this signature is of my predecessor. Somebody must prove this sale deed.
actually, Lordship, in the sale deed, no, the land, he's still residing there, Lordship. The
No,
petitioner is still
You
residing
don't get
there.
it. You don't get the point. You see, the reason is this is not the sale deed. This appears to be a certified copy of the sale deed. Is this a sale deed?
Yes, Lordship. Very good.
You have the original copy with you.
I will provide, right now it's not with me, Lordship. I will provide it on the next day. And he's still residing in that land only, Lordship. His grandfather has purchased the plot
Because
of land.
this is something which, in the absence of original, I can't read. What is the consideration value here? What is the sale consideration? Sale condition is 1,000 rupees for 3
Yes,
bigha land.
Lordship, 1,000 on a concentration of
No,
rupees
that's okay.
1,000.
For 3 bigha land in 2015.
Yes, Lordship.
Is it acceptable? This is, what is the date of this sale deed? Deed of the sale.
17. 12/2/2017, Lordship. Type copy, page number 22, Lordship. Kindly see, it's written the date.
2017.
12/2/2017, Lordship.
12/2/2017. So 3 bigha land in 1,000 rupees. No, not There's something wrong. It can't be 2017. It has to be prior to that. Hmm?
Lordship, I will provide the original cell deed if required, Lordship.
Just a moment. Salary 70. I see. See. Hmm. But how do you prove the rest of? How do you-
Lordship,
how do you
there
prove
is
the-
a typical error, okay, Lordship. It is 12 to 1970
No.
cell deed.
Actually, say we don't know about this. Now, please tell us.
I have
Please
stated
come to
in
page,
paragraph
come to page 48. The first 4 paragraphs. The court has given a reason not to disbelieve your documents. Because of a gap between 1971. And therefore, the court has questioned whether you are the same, your father and grandfather to whom you are projecting to be the son or grandson. There's the same person.
Lordship, I'm residing in the same plot of land only, Lordship, the cell deed land, which were.
But you have not introduced any document to show that you are in the same land. And in 48, there are these 4 first paragraphs. The court has given reasons not to believe you. Because the court has done, the tribunal has done that calculation. You claimed in your cross-section that you are 54 years. Therefore, the tribunal made a calculation and said that in 54 years in 2016 would make you born in 1962. But in your affidavit, you say that your father came into that village in 1971. So that is the reason for disbelieving you. If you have shifted in the village in 1971, you could not have been born in 1962.
Shipi was born in 1962 at village Garaki district, Nagaland. While he was a minor, shifted along with his grandfather and father to Borojol village, Nalbari. But he have never stated in his cross-examination that he was born at village Borajal, Lordship.
No, you said that you are born in 1962. Correct?
Yes, Lordship.
1962. And therefore, as per your version, in 62, your father was in village Barajol. Look at your evidence on affidavit. In evidence on affidavit, you say that you have shifted, your parents shifted to that village in 1971.
But here in this one, cell deed annexure for that one address and this one village residence, everything, though he's still residing there, Lordship. So it proves the lineage, no, linkage, Lordship. And his name has been appeared in voter list of 2014 also, showing his father's name, Lordship, in page number 40, annexure 8, Lordship. Page number 40. His father's name is Nur Muhammad. Yes, Lordship. In regard, Lordship, I will produce the original cell deed, Lordship. And Lordship, his paternal uncle also has been declared as a citizen of India. I have annexed the impugned judgment order in page number 40. Paternal uncle, because grandfather's name is Malik Sheikh and his Lordship, kindly see page number 49. Annexure 12. Type copy. Four nine, Lordship, Annexure 12.
No, Lord.
Yes, Lordship, it's before the foreign tribunal. Gograpar Assam. Page 49.
You have placed this order before the tribunal.
No, no, no. No, Lordship, I've not placed this order. Even in voter list also, his father's name has been reflected as Nur Muhammad, no, Lordship. Yes. I've annexed the NRC details of his father also, Lordship.
Being up next Monday, be prepared. We won't give you more than 5 minutes time to explain it to us. We have already heard you. It's just a young lawyers, so that we are giving you a time of 5 minutes more on Monday. Be prepared. Don't make the repetitive argument. Start from where we have stopped. Correct? 5 minutes. What side they represented? Miss
KLR Yantan.
KLR, yeah, from counsel for the petitioner. Has made her submissions. Query of the court. Case for him is granted time to address the court. Next para list on 29 7/20/24. Just record the respondents are all represented. Okay.
Item 7,
May please, your lordship. Lordship, in this case, lordship, petitioner declared foreigner whose
So the court had made a query on the last occasion about the change of your surname from Rajbangshi to Das.
Yes, my lord.
Now you address us on that first.
My lord, in this
Because there's no question materials on record. Therefore, you on that point, we are not satisfied. We dismiss your the petition.
My lord, we annexed, in this case, we annexed, my lord, page 18, the title says affidavit, my lord. Page 18, my lord,
Page
18, 1/8.
No, this page 18 was already considered by this court, and then it is recorded that there is absence of cogent material. Definitely, you must have argued on that date also.
Yes. Das and Rajbangshi.
Self-declaration will not do.
Yes. Not, petitioner herself name appeared in the voter list of 1970. Petitioner herself name appeared in the voter list
No,
of.
no, you see, it's very simple. I get the name of someone from the telephone directory. I find one name which appears to be attractive, Amitabh Bachchan. And then I file an affidavit saying that my name is, earlier it was XYZ. But from this and this date, I have changed my name to AB.
This affidavit. wrongly added in DW2, then DW2 and DW1 proceeding. DW says my father was expired before 22 years back. And DW1 says my father was expired 78 years back. That is the wrong and my discrimination of the name Devi and Rajvanshi. That is only my lord.
No, you project, as per the order, you projected your parents' name as Rajbongshi, na?
Sanatan Rajvanshi.
And Kumudini Rajbongshi.
Kumudini Rajvanshi is my mother.
Sanatan,
Rajvanshi father.
father.
Yes, ma'am.
You have projected them
Sanatan.
Sanatan Rajbongshi and Kumudini Rajbongshi
Yes.
as your parents.
Yes, ma'am.
Your brother DW2
Yes.
said they are Sanatan Das and Rajbongshi Das.
That Das and Rajvanshi, my lord, already, my lord, my father make a declaration before the magistrate, my lord, in the year of 1988. Since the surname, my lord, only.
I know, so but the
Since the
statement of your brother doesn't say so. Evidence of your brother.
This part, my lord, not able. That name and my lord, most important, my lord, the petitioner herself name appeared in the voter list of 1970 when she was attaining the age of majority. At that time, she was 21 of years age.
Where is that?
My lord, Annex 3, page 16.
This is something which has come in your cross examination. In your cross examination, you say 7-8 years.
Yes.
So therefore, your opinion is right. What is the date? Your brother said that your father expired?
22 years back.
Huh?
20 years, 22 years.
And you say 7 years.
7-8 years.
You see,
There is a contradictory.
You say 1 or 2 years, maybe plus and minus, I understand. But 7 years and 20 years is a long difference.
Yes.
DW1. Only was.
Where is your WS?
WS, my lord, is 27.
27.
Yes, my lord.
Everything is a mismatch.
Name of the husband.
Name of my father was Sonatan Rajbongsi and
The name.
the name of my mother was Kumudini Rajbongsi. And they were expired about 7-8 years back at Lotibari. My parents were regular voters and not concerned about us as to whom about
The names of, not concerned about as to when the names of my parents were enlisted and
my parents were registered voter and not concerned about as to
when
the names of my parents were enrolled in the voter list.
the contents of the contents of
The contents of the voter list
is
submitted for
me.
On behalf of me before the tribunal. I am also not concerned about about the documents as being filed on behalf of me. I have submitted all documents as being filed before this tribunal
Submitted.
Submitted by my brother named Ketramohan Das, namely Ketramohan Das. I have not produced Ketramohan Das as in the witness box as my witness today. I am not aware about
The contents
the contents of various papers and paragraphs of examination in chief on affidavit written in English. The name of our Gaubura is Sedon Gaubura, and I have not produced Gaubura as my witness before the tribunal. I have two this one. I have two sons. I have three sons, namely Kusi Mohan Das, Susi Mohan Das, Joyson Das, and Rupsan Das. I have four sons. Das.
Which is the document to connect you to your father and grandfather, sorry, your parents and her grandmother? Because your parents and grandparents, their names were Rajvamshi. Then you have introduced your brother whose name is Das. Surname is Das.
Yes. Change in title.
You will have to link through your father,
My lord, there is the link.
or if you are linking through your husband, then there has to be some collateral evidence to support that, yes, she was married on so and so date.
I was a illiterate lady. I was married before achieving the age of majority. When I was at 21 years old, my name is appeared along with my husband, my lord, in the Bhutan list of 1970.
That is all right, but whether you are that lady, how do you link it? The fact that this the lady at serial number 89, page number 16, and the petitioner
Yes.
are one and the same. How do you say that?
My brother has come and deposed.
Your brother has made contradictory statements.
Yes, only age of, only the death of my father. That is only contradictory.
Not only this, the surname also.
Surname, my lord, to make my lord, my father make a declaration before the judicial magistrate's first class Bogota in the year of 19.
Now, see, that's not believable. Rajbangshi will not change this surname and become Das. Because if I don't know, I may be wrong because I'm from a different community. Das would be an OBC.
Yes. That's OBC.
So why would a Rajbangshi become an OBC?
OBC, SC, ST.
Because Rajbangshi themselves, they have reservation. Rajbangshi have the reservation.
OBC has a reservation.
Huh?
OBC has a reservation. OBC is a reservation.
No. Rajbangshis have a reservation.
Yes.
So why would he become an OBC and then have a reservation?
Yes.
Why would he change?
May I assist him?
Definitely, you lead him. Why would he assist you? Lead him.
Well, the idea of changing the title is not that he want to be OBC or they have changed their name, their title.
No,
And for that, they have sworn an affidavit to that extent 1988. His father, her father.
This shows the record.
Yes.
For a moment. When was the reference registered?
Reference.
Borpeta Lordship.
What is the date of registration?
The string.
But another thing is very important. But in the reference, there was a mention of this.
25/6/97 Lordship.
You see, it's 97 reference.
Yes.
So if you change your name after the reference,
Before the reference.
Before reference.
88.
88.
88.
Yes. And my lord, in the opinion, there was a mention of the stream. There was a mention under which stream I am foreigner. Kindly.
Reference of para 16 close to.
No idea.
There are so many decisions, Lordship, regarding self-sworn affidavit, Lordship.
And also
But if it is 68, that means it is, the declaration is pre-existing, the reference.
Any line reference say page number 13 number देखे थे इसमें हाँ mention reference तो नहीं लगा
No, page 13, both of it.
You have the affidavit in original with you?
At that time, no.
Original is not here.
I will put it.
The next question.
Next question, original question, na?
Original.
Below for me.
Asana নাই মানুহ ক'ব নোৱাৰি।
Modification report. Anything else? Mhm. Mr. Biswas, anything more?
No, my lord, this is my submission. Now, my lord, my brother who was deposed before your lordship, before the tribunal, my lord, he has categorized that she is my sister. And the only difference is that when he died, well, rustic people, they have got
But
no.
is it sufficient to rely on that evidence that you make a statement, she is my sister?
Well, only the contradictory is that she said that 7, 8 years.
No, how have the brothers been linked to her father? Is there any document to show that?
My lord, Falani Devi, daughter of my lord, this is Panchayat Secretary certificate is there.
But he was not examined. It was not proved.
In the reference also, your lordship will find it, my lord. And my lord, regarding voter list, my father's name is there. Of course,
that is-
not with me, with my husband.
But that's all
That
right.
is there for the year 70.
Mr. Biswas.
Yes.
Our problem is that we are sitting here for 4 days. Every day we are enriching ourselves with the cases cited at the bar. Now we have been shown decisions where it says that there is a requirement under section 9, under rule 9,
Section 9.
section 9.
Burden is
So
on-
the burden is on the proceeding to prove.
Yes,
So
yes.
therefore, even if it is written in the LBO report,
My lord,
that itself doesn't become an evidence.
with all respect, my lord, latest judgment of the Rahim Ali, I think your lordship is aware of it. I have got, I beg apology, I have got only one copy, 64 pages. There, all these points have been discussed. Of course, the man is no more. He expired before the judgment pronounced by the Supreme Court.
What does it say?
My lord, all these questions have been discussed
elaborately. The discrimination is name, age, title, and place, because spelling wrong mistakes, how the when the people goes to list the name of the voters, they write wrongly. And there is a difference of spelling in different languages, Bengali, Assami, everything has been mentioned. Urdu has been specifically. And in this judgment, responsibility has been given to the government also.
What do you say, government?
Lordship.
Recent judgment, latest judgment.
Latest judgment. Last week ago, right?
You're not aware.
Lordship, I am aware about that.
Oh.
But Mr. Biswas, this doesn't help you. Here what had happened was there discrepancy of the name.
Yes.
And the tribunal did not take into consideration the opinion given for one of his siblings, where he was held to be a Indian citizen.
Yes, here Supreme Court itself declared him Indian.
But his sibling was declared to be an Indian. That was not considered by the tribunal.
Yes.
That's
Tribunal address our own High Court also has not considered this.
Huh?
Our High Court has also not considered the judgment. Same
Which
judgment
one?
has been upheld by our own High Court. That was under challenge in the Supreme Court.
No. But Supreme Court, this writ petition was allowed by this appeal was allowed by the Supreme Court on the two grounds. Number one, spelling mistake.
Spelling mistake,
And
disclosing
then
name.
one is a ground that the sibling was declared to be a Indian,
But,
not a foreigner.
with all respect, judgment of Sarvananda Sonal also has been discussed here.
Yes.
Little bit. Yeah.
Yes. So that is a reverse burden of proof. Section 9 is approved. Reverse burden which has been imposed by virtue of the judgment in Sarvananda Sonowal. That has been approved by this bench also.
But
Yes.
full responsibility, some responsibility of the state also has been discussed probably, madam. I have gone through it.
No. You see here the categorical finding, you set aside all this. Now, Sibling was declared to be a Indian.
Yes.
You see page para 43. So once his sibling is an Indian, there's no difficulty in accepting it. But that was rejected on the ground of the error in the spelling and all. That's what he said in paragraph 44. There are some discrepancies, but that discrepancy would not mean Rajvanshi to be written as Das as a proof of the lineage.
Required to be taken into account.
Did you see earlier opinion of a sibling can't be ignored.
Yes, very true.
Therefore, if there is minor discrepancies for which the tribunal has rejected, that is in paragraph 43. Forty-two, 43 is and 44. 44 says from an overall discussion of the report of the tribunal, it is clear that there are minor discrepancies in the applicant's documents. So minor, you see when the siblings, one sibling is declared to be an Indian, the other things will follow. If there are minor discrepancies, that will go.
Moreover, my humble submission, the Citizenship Act has been already amended. Citizenship Act, where all these persons, Hindu, Christian, Buddhist of Bangladesh have been accepted, included as a citizen.
That will be your alternative argument. Then we are admitting.
But I talked to my friend the other day, why even the tribunal, they have stopped the taking cases on to send the notice to Hindus or Buddhist or Christian, those who are raised. And
No.
High Court cases, we are facing it.
No, for that you can have an alternative argument saying that you want to withdraw this and pursue that remedy. But if you have to determine this determination, then it has to be dismissed because if you can't link it.
Because I don't claim that I am from Bangladesh, that's why.
But you
I
just
cannot withdraw it now. That is the
you just submitted.
that I submitted. The law has been changed. Government ought to have taken steps.
No, so how does
In
it
the
affect?
respect, there should
How
be
does
some
it-
circular.
How does it affect you unless you fall into that category? Change of law, how does it affect you unless you also fall into that category?
No, my lord, problem is that even if I declare foreigner, they are not sending to me for Bangladesh. They are refusing. We will not accept it. Anyone.
That is another part.
Yes, they will be stateless.
Because-
That also I have read the article yesterday in some newspaper or some books I have read.
Because that is one part.
That's
Yes.
a bigger issue.
But right now we are concerned with the smaller issue of
Yes.
of this writ petition. Big issues, there are people who will discuss.
Yes,
There are small
very
issues.
good.
Yes, what do you have to say, Mr. Sharma?
Lordship, regarding self-sworn affidavit, Lordship, in Lordship, our High Court has a case, Lordship. So many decision has been passed, Lordship. One of that is 27 WBC 2751 of 2019, Lordship. Para 12, Lordship. Lord,
Oh, no, this may not help you.
Para 12 lordship.
This may not help you. You see here what had happened is that the change of name affidavit was sworn on 16/3/2017, and this reference was answered. The opinion of the reference was made on 28/12/2018. That means this affidavit was sworn after the reference was made. Perhaps during the pendency of the trial of this. But here is a case where the affidavit is of 1968.
Yes.
1968 affidavit, if you don't dispute it,
88.
88, 1988, before reference. So it's not a document prepared after the reference was made.
Huh?
It was 88. When is what is the date of this reference? 88 and 16.
Yeah.
And lordship.
Just a
Apparently-
moment.
Yes.
Just a moment.
Reference is 98 one. 1689/C 98.
I'm not getting it.
Reference is 98.
98.
Yes. In page 35, you'll have to get it.
Okay. So 10 years before that. So the intention was not to create an evidence for the trial.
That is true, but lordship, apparently lordship, here proceeding could not able to establish his link with his projected father whose name appeared in the voter list of 1966 lordship. Yes, Sanatan Rajbanshi lordship. And lordship, they relying on that certificate, even on death certificate also lordship. He was written as daughter of late Sanatan Das, lordship, page 22. And that was prepared in the year of 2015 lordship, after and proceeding is going on lordship.
Not supported it by producing materials to his name appearing on or in
You have to dismiss your petition because if whatever documents are there, let us forget the 88 affidavit for the time being. That is on behalf of your husband's family.
Yes.
But citizenship you will have to prove from your own parentage. From through your own father or grandfather, you have to for that there is no document.
Right, right.
There's only one evidence of your brother. The brother has not produced any document to show that there is a common. They were in the common household, or they are the sister, or there is any voters list or any other document showing them as brother and sister.
All right, we'll take it up on Wednesday. You go through the judgment and apprise the court. This Rahim Ali. Are you aware of the judgment?
Yes, Lordship.
Why the tribunal can travel beyond reference method? That is to be considered. In the reference, there is no mention on under which thing.
Heard Mr. S.C. Vishwas, counsel to the petitioner, Mr. Sharma appearing for the respondents. The petitioner is before this court putting to challenge the order dated so and so passed by the AFT Tribunal. There is the order. Page number.
34,
34 minus 34. Page 34.
Order dated
14/12/16.
14/12/2016, passed in FT case number 115 of 2016. The hearing remained inconclusive, matter to be listed again on 7th. List accordingly.
Item 8.
May I please, your lordship? Interim judgment is at page 31. May I read small judgment, lordships?
Lordship. In this case, the father of the petitioner has been declared to be an Indian citizen. Lordship. What is more to be adjudicated? You go through the LCR, what do you? Yes. What is the exhibit number of that?
Exhibit 7, lordships.
Yes.
Father's judgment.
Father's opinion.
6, lordships.
And how do you
Exhibit
link
6.
yourself with your father?
Lordships.
What
That
is
is
the
also
father's opinion?
that father's opinion dated, lordships.
Is it page
Page
26?
15.
Yes.
Page,
Page 26?
Yes.
yes, lordship, page 26.
How, but what you call? Before the tribunal, did you produce this?
Yes, yes. Those documents.
Which exhibit? That's what we are asking you.
Yes.
Exhibit 6.
Exhibit 6 also produced and the brutally NRC
Tell us the
19.
exhibit number.
Tribunal judgment is exhibit 6, lordships.
Exhibit 6.
In my read petition, page 26. In the LCR, page 46.
Okay. And how have you linked yourself to your father?
Lordship, along with my father's, my name also appeared in those brutal lists. My
Which
father's,
one? Exhibit?
that is exhibit 3, 1997, page 14 of the read petition. And my father also adduced evidence, lordships.
You want to see the trial court record?
Small.
In this case, what has happened was that you come to page 32
Of the record
of the no, not record.
of the writ petition. Yes, sir.
Fourth paragraph, from record it appears that Oki's
Perfect.
projected father so and so and his grandfather, whose name was so and so, appeared as so and so, so and so, so and so. Now it is rejected because in 1951 NRC, projected grandfather's name is appears as Montar Ali Sheikh.
Yes.
Now you can't take two stand. When the proceeding brings NRC, then you say that it is not admissible document. But when the tribunal is dismissing, you say it is an admissible document.
That is understandable, my lord. I admit, my lord, your lordship, in this case, very interestingly, in WS, nothing has been pleaded, all these things. Your lordship may kindly see the WS, my lord, because he cannot plead beyond the WS, my lord. WS, my lord, in fact, this is very cleverly, my lord, this case has been done. Your lordship will find WS at page 18, my lord. 1-8. Not even father's name has been mentioned in the WS. I'm not going to say about my grandparents' name. This is WS, my lord. Your lordship will find that there is no cause of action against the opposite
No,
party.
he's saying it. He does not give the name, but he's in paragraph 7. He's saying the name of my grandfather has been recorded in NRC.
NRC,
The name of the father and opposite were recorded in the electoral roll. He's saying that.
Yes, but
He's not giving the name. That's okay.
my
But
lord,
he's giving the details that my father's and my so and so names are there.
but my lord, my submission is that this affidavit was filed in my lord on 29th day of December 2012, when this opinion did not come forward.
Correct.
When this opinion was not there. So it was intentionally filed, my lord. It was intentionally, names were not given. Even grandfather, who is the mother, that has not been given. These facts has to be given in the WS, my lord.
Show us
Otherwise,
the record. The name of the proceeding?
Antapani.
Antapani. Remember, I need to say he is the same person. TWP is TWP, father. His father. No, that's the first. In a query me. He is not been able to make answer. He is not submitted any voter ID, photo ID, disclose his photo ID. PW1 is he himself. Antapani. PW1 is Antapani. Proceeding.
You've seen the records. The proceeding has not been, his evidence is not questioned. When his father came, these questions are asked. And when did his father cast a vote? When did he cast a vote? Yeah, I don't remember.
Madam, why I'm submitting, madam, let me submit the details, madam. Because, madam, your lordship may have to examine it carefully. Because in the initial stage, when the WS was filed, he's silent about his residential address, he's silent about his father, he's silent about his mother. Now, madam, your lordship will tell why I'm saying. If he is the son of that person and they're residing as per record, if this is the correct, they're residing in the same house. But why he did not disclose about that his grandparents was there in 1970. That document was not disclosed at all. If we say, my lord, if you see the my lord, correctness of the order, my lord, the my lord, tribunal has no other documents before him prior to 71 except the NRC document. He did not submitted any documents of any of his lineage, my lord, prior to 71 except this NRC. So the tribunal has to bring some lineage from person who was there prior to 71. So where there was not a single documents prior to 71, which he submitted, my lord. Even in WS, neither in WS nor in the evidence, my lord. Now, when this person has been declared Indian,
Evidences, everything.
Evidence also.
I'll submit later.
Evidence is there, my lord. Evidence submitted only after the, my lord, declaration of the father, the projected father as Indian. This WS was filed in 2012. Evidence is filed in 2016, after 4 years. And that is only after the declaration of that person. And these facts, who is his father is there is a case against his father, and his grandparents were there in 1970. Nothing is disclosed in the WS. Only these facts has been brought only after the declaration of that projected.
You'll have difficulty in convincing us. You see, the state with all its might had the opportunity of asking those questions in this. The veracity or the inadmissibility of the new documents in the evidence could have been questioned to him, but he was not put any question.
My lord, he submitted as per the, my lord, the opinion, he submitted 1951 NRC, which is documents of prior to 71. This is the only documents of prior to 71. Page 31, my lord.
No, but
yes.
But again, you see, the tribunal takes note of this 51 and rejects it because of the discrepancy in name.
No, my lord,
This is admitted.
Why it was rejected
No, that is, I'm not on the rejection. You see, name sake, SK.
Yes, no, why it was considered, my lord? Why it was considered? Because tribunal had, my lord, before the tribunal, there was no other documents of prior to 71 of the parents and grandparents. That's why probably the tribunal considered. This is the only documents of, my lord, a person who is claiming that I'm the son of or grandson of that person. He must have, the father or grandfather must have some documents or some existence prior to 71. If I claim this person, my lord, whose name was there in 1951 in the NRC, he was there, existed in prior to, my lord, India prior to 71. At least, my lord, my submission is why they did not disclose anything about the 1970 voter list, which the father disclosed.
In the
Father
WS.
exhibited it.
In the
In the WS, my lord. Not even evidence also, my lord. Evidence also, he has not said about the 1970 voter list. Evidence, DW1, my lord, page 20. Page 20, my lord, this is the evidence. He has not stated about the 1970 voter list, which the father relied on the basis of which father, the projected father has been declared Indian, my lord. My lord, may kindly see the page 20 is the evidence.
We filed W.
That's because, my lord, he did not disclose about the 1970 voter list. So there was no question of asking him during cross-examination. And the NRC, it is not admissible in fact. So NRC could be ignored itself. But even then the tribunal considered it. In fact, NRC should not have been considered, my lord.
What is your submission as to the evidence of the father? He made a.
No, not that's why the tribunal also said, the first of all, identity of the father, whether he is the actually father or not, he has not brought any identity card. He has not brought anything. Somebody may be picked up and he may become.
These are questions not put in the cross, I think.
That probably that is not matter, but the tribunal has observed that the identity of the
Tribunal is to consider what is there in the evidence.
Yes.
So whatever he has stated in his chief.
I have not seen the cross part, my lord.
It's there, have a look.
See, there are two things. Number one, even notwithstanding this surveillance Sonwal one, the OCD says that this is the NRC of my grandfather.
Yes.
Now, let us take it that the NRC is not a
Admissible.
proof of citizenship. But can you say that the entry made in the NRC is not even a proof of the relationship?
My lord, in case of NRC, it is not said that it is not a proof of citizenship, but it is said it is not admissible as an evidence.
That's okay.
Yes,
Not an evidence with regard to citizenship.
not
So that's okay.
not admissible as a document, my lord.
No. It doesn't say that.
No, that is the point. my lord.
The reference is of 1970.
Yes,
In 1970, Assam, Nagaland. I don't have that.
I have,
1970, Assam, Nagaland.
yes,
They say there is not a evidence with regard to citizenship. Accepted.
my lord, what, may I read that portion, my lord? That
Show you something.
Judgment is not- My lord, that is 1970 Assam alert 206.
Question is, when you think it is to be used as a document for establishing the family relationship, then it must be true. And it has to be an activity. And if you say general reason for conflict is okay, and then you don't admit it, consider it as a past. Nothing else. Now, if it is being used, maybe not maybe a ground for citizenship. It establishes some limitation. In that basis, there is no limitation. Not even found the so we have to first say. There has to be some procedure has to be followed. So NIC citizenship is not there. By way of a reference, you are not examining the veracity of this evidence vis-a-vis the case of the victim. That is not been done. For that to be done, we have to implement it. So we reminded, we like to clarify that see, without being a document possible. But yet, maybe it may be done, it changes the culture. Police organizing. It is not an investing, it makes the very easy. You have to be very easy to come like you up to. Then With this chart, the pieces of so we really could say that the document is this document establishes and I'm done with the burden. We not do it all. You have to see, no, maybe there has to be, okay, you establish the identity of so and so, you give us some of the documents, we say, oh, it's for the difficulty is when you know this brand, you know, total capital will have to be given assessment by the tribunal. And also by us. See, then this procedure is the procedure is for extending our coordinate such as relying on the government to be efficient. But we can certainly we can do how do you evidence everything is about can we how can we do now we already do that. You have to go that you must see you not be people to do it. Once it is there must be popular to do it. Whether it is used to get because we exactly you must be saying no, I'm not going to be. Technically, over there are no other volatile so whether we should clarify because now they're proceeding only from the NMC is not a document for citizenship. You're not even considering. If you respected visit, so and even people who are saying NMC definitely we have to verify that which we were following all these years that NMC is citizenship. That we have to be visible first. Some very that we should. Then the next line of material means that we have the energy to establish the integrity. We can do it. So we open
Yes, my lord, your lordship may kindly see the judgment of that judgment, my lord. That is ALR 1970 Assam Nagaland 206. That I may read that part, my lord. The
You have a copy of that judgment?
yes.
Vanabasha.
Yes.
The last part, second last piece, my lord. Second last page on the left side. That's because it was prepared under census act, section 15 of the census act. Section 15 of the census act has been quoted.
What is the purpose of the NRC document?
NRC at that time, my lord, for upgradation of the names.
What does it reflect?
Records the name of citizens,
Citizen. The families.
Whoever is there at that point, those names will be recorded. But at that time, it was done under census segment. It was done under, now it is under the 2003.
This appears to be. Says this is not public
But there are other things that another method.
No, the issue was citizenship, obviously the,
That's why I said that we prefer this.
It was with, the issue was with regard to citizenship, you're
Citizenship.
right,
yes.
but the rejection of the NRC is not on that count.
You see, what had happened was, in Tejpur, that Jamaat-e-Ulema had given a printed certificate. You read it, paragraph 8.
Yes.
That was given.
Yes.
And then the court quoted it, discussed it, and said that this is not a public document.
Yes.
It doesn't say that it's not a proof of citizenship. Because if it's not a public document, it can't be a proof of citizenship.
Yes, that is true.
So that one line perhaps is being quoted, and then this only one line remains. The context in which this judgment was passed has lost its, what do you call that, force.
My lord, made it the next portion, my lord, because I was supposed to get that part. My lord, if so, section 15 of the Census Act will make such record of census not open to inspection.
No, now it's, you see, it's not a question now. The reason being that this NRC has been brought into the domain, public domain, by making it available in the internet.
Yes.
So for the purpose of legacy, you are now permitted. Earlier, to prove legacy, you are not permitted inspection.
Yes.
That was perhaps the those days in 1970 when the judgment was passed. But is this status same today?
So this is now also, my lord, in other judgments of this honorable court.
Do you have the Abdul Majid and Aiton Nesa?
Yes. Abdul Majid, para 11, my lord, it is.
Abdul Majid.
Look, even though, my lord, what my submission is that, and prior to 71 accepted NRC, there was no document of any person before the tribunal. So NRC was considered, even though, my lord, this law says that it may not be considered, but tribunal considered, rightly or wrongly considered. And tribunal has recorded the findings, my lord. As per the finding, my lord, this has not been, the grandfather's name, what is recorded in the NRC is in of a different village.
Is over?
Different village. Of a different village where the petitioner and projected father resides. And my lord, the name of the grandfather in the NRC is also some extent different. Because the projected grandfather is Montas Ali. In fact, that's why, my lord, I pray before your lordship that submit, my lord, that he should have mentioned all details in the NRC, my lord, in the WS itself. Who is the exactly grandfather?
There is also a judgment, I think. There it says that what is the effect of
non-mentioning of WS, my lord. Those judgments are there produced on this, my lord. But that's why I'm submitting, my lord. This should have been mentioned. Otherwise, my lord, the identity, it may change in any moment, my lord, like in the present case, it is the best example where the pleadings have been changed from time to time. Initially, the grandfather name was not given. Why his name is, my lord, an Indian, if it is the same grandfather, why his name was wrongly spelled in the NRC, that explanation is not there. So how can the tribunal presume that it is the same person? Tribunal cannot presume, my lord, if he did not, it is his personal knowledge. If he say, in the NRC, my grandfather's name has been wrongly spelled, or he was in a different village, but subsequently he shifted to this village, we are residing in this. If he doesn't explain anything in his WS, nor in the evidence, my lord, tribunal cannot presume that it is the same person. How can tribunal presume? So tribunal has no alternative but to give
You have your representation there. You could cross-examine PW2 and DW2. Why not DW1? Mr. Pang, please understand the difficulties. You have to tell us so that we can overcome that. Now you see, witness, the person comes into the witness box. You don't ask him anything, you say go. And then the case is dismissed. You forget about this particular NRC or the sentiments which are attached to it. You see in a pure form of litigation. Somebody is before you. You don't question him. Not even a single question that in your written statement you did not introduce it. Now you see what happens. I hope you are aware of this CPC. You see, if there is an essential basic facts given, readings are complete.
Yes.
Correct. You have the CPC?
Yes.
Now you see in the CPC you will have to come to Appendix A. You've seen any form? Just see any form.
Yes, but Appendix C, I have found it.
Huh?
I have found it Appendix C.
So you see, it doesn't say how much you have to plead.
Yes.
Correct. For money lent, it can a good plaint can be 6 paragraphs, including prayer. So I'm just showing you the form.
Yes.
It doesn't require that you give each and every detail. That means basic pleadings must be there. And then you give your evidence. Correct.
Yes.
Now, under the new CPC, you may forget there are what you call inquiry required to be made with regard to Order 11.
Yes.
And then proceeded. So even if some particulars are not there, still now the court under order 11 can make inquiry for discovery. That's one part. Now, you have the copy of Citizenship Act.
Yes.
Please come to citizenship, registration of citizens and issue of national identity cards rules.
2003. Fairness.
Now, you've got these rules as 2003 rules.
Yes.
In 2000, come to 13. General Register General of Citizens, so and so authorized in behalf shall issue national identity card.
Yes.
So therefore, this is not an NRC of 1951.
This is not.
It has been amended.
Yes. This is
Now
new.
you'll have to
This
show
is-
us that the law which was laid down in 1970, Assam and Nagaland, is a good law.
My lord, what my submission is that.
No. Submissions is one part.
Yes, I
We are
understood.
trying to analyze. You see, nobody's made that argument.
Yes, yes.
The law must be same to follow the 1970. Now we are permitting not only this, we are only also permitting them to give a identity card.
Yes.
If one gets an identity card, why can't we use used as a proof of identity?
My lord, the NRC prepared under 2003, it may be accepted as a piece of evidence because NRC 2003 is under my lord this.
No.
Citizens.
No.
Because-
That argument will not hold good.
Because my lord, that was rejected only because my lord, that was prepared under the my lord census side.
We'll tell you why. Because this 2003 rules is merely permits an updation.
Yes.
And therefore, now when you download it now, after the incoming of 2003 rules, you can't say that this rule NRC is 51. NRC name will be 51 only. If it's a data of 1951. After 2003, 1951 data, we can't say it is 2003 data. And these rules
That I
does
have
not
to-
reflect to any repealing law.
Yes, my lord, that I have to take section exactly whether it be the same or not. Because what my understanding is, my lord, that was prepared under census act, that was a different document. And 2003, this is the present NRC updation is under 2003 rules. So it will have a different effect, my lord.
So why now we can't use this? You address the point.
Yes. Address, I was address. This is under Citizenship Act, madam. 2003 is under Citizenship Act.
2003.
Yes,
Yes, under Citizenship Act.
yes, this is under Citizenship Act. And that was under my lord census act.
Okay, we'll continue. I'll tell you why. In the act, you please see 14A,
Citizenship Act.
Citizenship Act. Issue of national identity cards.
Yes, ma'am. Issue of-
This has become mandatory, therefore it has come in.
Yes, ma'am.
So under the NRC, one can still have an identity card. Maybe because people don't know about this, the people are still downloading the NRC from from the NRC website, and they are taking it. But in form and essence, we have not come across a subject. We are always subject to correction. We have not come across any document which says that the census operation in 1951 that NRC prepared would not lose its credit, because that becomes a part of this 14A, and under 14A it is required to be compulsorily registered. (14A)(5) you will find compulsory registration.
Yes.
So once that is there, the law will have to address us that the change of law. Why is this still we should consider this 1970 judgment in the said context?
I'll see it.
It will be taken up, Lordships. Next date is tomorrow or
It's not tomorrow, next week.
Heard learned counsels for the parties. Hearing remained inconclusive, matter to be listed again on. When would be convenient for you?
Next week. Yes,
Next
Thursday.
Thursday? 8th.
8 o'clock.
Not 8. Have it on 7th, or you have it on 12, 13 like that, whatever.
12.
12.